Act for admission of workman compensation.
Madam, may I have lordship slip to mention one matter. Though I am the petitioner respondent, appeal is preferred by the state respondent. Wherein, my lord,
What do you want, sir?
let it appear as a to be mentioned because the pension
Give-
payment order has been issued.
Give.
My lord,
Only
first
pendency
appeal
of the appeal.
Yes,
First
give.
appeal admission. First appeal admission.
Admission, first appeal does
And
not.
application.
Application. Which year?
Huh?
First appeal of which year?
2025.
First appeal, I don't have a determination of 25. আমাদের 2015 পর্যন্ত। We have only up to 2015.
May I?
I permitted for mentioning application for substitution.
Go before the Lawajima.
Out of time versus.
He is setting aside abatement.
May I have my lord's kind leave to file a mandamus appeal without a certified copy, my lord? My lord, today I have appended the
When
application.
the order is passed. When the order was
My lord, on 12th of February 2025, my lord.
applied for certified copy.
My lord, yes.
Server copy is here.
Server copy is there, my lord.
You will obtain certified copy from there.
My lord. Grateful, my lord.
Lordship, I am seeking leave to file an appeal without certified copy. Order dated 25th February 2025. I have yesterday's order.
You applied.
Yes, Lordship.
Have you annexed the copy?
Yes.
Lordship, may I permit it to mention for matter for inclusion, content matter.
Of this bench?
My when Shompa Datta. Shompa Datta, my.
এই দেখো তো ওনার সঙ্গে আছে কি আছে দেখো।
May I have your lordship's kind leave to mention item number 12. Well, yesterday the order was passed. My lord, it was the desire of the court that the matter will be taken up from today.
Yes, we'll take up today. Don't worry.
No, from item number 15 onwards, the matter will be taken.
See to it. Let us see.
Next week, 2 weeks, my lord will not be here. So, my lord, only one request. My lord, if your lordship kindly make it hard in part, because my lord has heard
I
this
never
matter.
did in my career as a judge. Never, not a single matter you can say that I have
If
kept it
the
as-
determination changes, my lord, I'll be in a soup.
No,
No,
that's my principle. I never.
Very well. Well, then shall I request only one thing? Can it be tomorrow?
Let it be. Don't worry. I think they will not take much time.
No.
Mitro, will you take time? I
No,
don't think
not
so.
long.
Then can it be tomorrow, my lord, if your lordship
Yes,
can?
yes, will be. Don't
এটা
worry.
কালকে জজ সাহেব বলেন 12 নম্বর আইটেমটা কালকে রাখতে 12টা
কালকে দিয়ে দিও।
কালকে গ্রেটফুল
Yes, yes, next.
12 আইটেম
Item number?
Number 2.
Item number 2.
First submission, cross-examination was not required. And my lord, the witness was incompetent. That is why cross-examination was not required. Kindly take up, my lord, the first volume. The application, my lord, starts at page 134. Page 134. Kindly come to, my lord, page 151. The same person affirmed the petition. The objection to this starts at page 215, my lord. Lordships can take it from me that there was no challenge to his authority in the objection. Now, my lord, kindly take up this second volume, page 254. It's not required. These are the, my lord. No, it's first one. 254. Yes, 254. I'm sorry. Kindly come to page.
Only certain questions on resolution, board resolution and all.
Not a single suggestion that, my lord, he is incompetent or he cannot depose. That was, my lord, in my full submission. There, my lord, canopy it comes in. Had this suggestion been there, my lord, my client could have, my lord, if required, could have produced any other person. No suggestion. On the contrary, cross-examination on the documents. So, the, my lord, defense now sought to be made out was never there. The only question was page 254. The board resolution filed by me is the only document which will reveal my personal identity. So must be the question was, have you disclosed any other document to reveal your identity? Personal identity. That's it. Interestingly, my lord, I am very certain that, my lord, Mr. Mukherjee was not told by his, my lord, client or by the, my lord, the lower court advocates that, my lord, when this witness came in to depose, they had made an application. The application will copy. That is part of the record, my lord. I have obtained certified copies. There are certified copies. Challenging his authority or seeking to challenge his authority.
Was there any order passed on that?
Yes. Dismissing the application. First application was when he filed his affidavit challenging that. On the same day, another application was filed. On the same day, another application was filed saying that he cannot depose. Both the applications were dismissed by a common. Copy the extra copy. George's copy কোথায়? এগুলোর কপি দাও other side কিন্তু আর অর্ডারটা বানাতে দিলাম একটা আগের দিনে অর্ডার শিটের বাঞ্চ দিয়েছিলাম আগের দিনে একটা অর্ডার শিটের বাঞ্চ দিয়েছিলাম লোয়ার কোর্টের আলিপুর কোর্টের এখানে শুরু হবে
বেশি কপি দিয়ে ফেলেছেন এটাও দিয়ে দাও ফেরত why you are giving an extra copy?
No, two applications. Two separate
Same application.
Twice.
Both are 20th of January.
No, both applications were filed on the same day. Kindly look into, my lord,
It contains the same words.
concise statement, my lord, the headings.
Heading is application for non-acceptance of the evidence.
And the other one is, my lord,
The same.
Oh, I'm sorry.
দিয়ে দাও
এইটা
এটা আলাদা. This is different. You have given me this copy already
very
for
good.
non-acceptance.
My lord, lordship knows, my lord, my
Nowadays you are facing a lot of difficulty.
thrashing of the juniors, my lord. He received one because he was taking time. So, my lord,
That's a blessing for him.
Justice Vishwash has got, my lord, the correct copies. Two separate applications.
One copy. I got one copy.
Oh, don't worry, I was a recipient.
These are two separate applications.
আরো বলি দিই। না, এটা দিয়েছে, না কেন?
দুটোই।
Same copy. Order 29 দিয়েছে? হ্যাঁ। Yes.
অর্ডারের 5টা পাওয়া গেছে? অর্ডারের 5টা পাওয়া গেছে?
Teach করা যাচ্ছে। You showed me on the other day the 8th March order.
Yes. That was, my lord,
Refusing to adduce evidence.
and now kindly come to the order of 24th of January 2023, my lord.
এটা কি আমার কপি? 20?
20, kindly come to page 29 of the order sheet, my lord. The pagination is at the top.
Yes. 24th January.
24th January. Both the petitions filed by OP number 1 and 2.
Yes. Yes. Rejected and recorded.
Yes. No challenge.
Yes.
Now, in the memorandum, my lord, kindly take up the memorandum once, my lord. I tried to show it to your lordships again. Lordships can take it from me. There is no challenge. There is no ground made out that the learned court ought not to have looked into his evidence or the evidence was inadmissible.
Even this order is not under challenge.
Order is not. তিনি দিয়েছিল না একটা অর্ডারে? প্লিজ একটা কপি দাও না অর্ডারের, ওই 24শে জানুয়ারি অর্ডারটার কপি দাও। 24টা খুলে দিয়ে দাও না, মিছিমিছি কাগজ বাড়িয়ে লাভ কি?
The full bar.
Very well, very well. I was trying to, my lord, reduce his, my lord.
They ought to have, once they prepare the paper book nowadays, nobody takes care of that. They have to include the entire order sheet. Now the juniors are not taught in that way.
Justice Standen, my lord, saw, my lord, the printed bound paper books.
Dr. Babu was there in the department. He used to prepare. And we used to go and certify.
Printed paper books.
Yes. Nobody has seen, they do not know what is the appellant declaration which is filed for the purpose of preparation of this. There is a documents, the preparation list of the documents
Yes.
is to be shown to the other side, that we
Yes.
wanted to include
Yes.
those documents in the paper book. That was certified by the other side. Or if they want, they used to write that these documents should also be included.
Those are not.
But these are
Those are not.
appellant's declaration gone. List of documents gone. Because Dr. Babu has gone.
In this case, just wanted to point out, my lord, there was a consultation, letters were written, we had forwarded the index to them. So this paper book was prepared
It's
by
not
the
a paper book. We are proceeding on the basis of the compilation.
compilation
I
also,
understand, my lord, from
the
the very
index.
beginning.
The entire order sheet of the paper book of the trial court. No.
Yes.
That's the one of the mandate under the paper book. List of documents means furnishing the list of the exhibits which you want to include.
All the orders should have been there.
That is not done. Nowadays, nobody cares. Read a dedicated chapter from the appellate side rules for preparation of the paper book. What are the requirements? Nobody talks about the appellate side rules, then nobody cares to read it. I think many of the juniors of the bar, if you ask him, they do not know what it contains. Even sometimes a surprise, it is surprise to them that there is an appellate side rules of the original side rules. Anyhow, yeah, it's a posterity who will take care of that. Yes.
Now, my lord, kindly once take up, my lord, volume 2 of the compilation. May I?
What for?
May I, my lord? Please, what they said. My lord, this is a copy of a civil revisional application from the order impugned. They had initially preferred a revisional application.
Yes.
The order impugned here. 21st April 2020. Yes. That is part of the paper book, the compilation. Then, my lord, it went up to Supreme Court. Supreme Court had sent it back. Be that as it may, my lord. May I please, my lord, page 398.
Yes.
Paragraph 20 kindly take into consideration. Your petitioner states that it is an admitted case of the opposite party number 1, that is my client, that they are the original lessees. They have never assigned the leasehold property in favor of the judge.
Admission there, they wanted that you have said.
It is not my case. It is an admitted case.
Careful drafting here.
Very well. Stay petition to the
Admitted what the privilege.
My lord, kindly look into.
It is admitted by the opposite party number 1 that
Very well. Very well.
a case na bole admitted by the opposite party.
May I show, my lord, this stay petition filed here? Part of the record of the appeal. Part of
Copy and paste.
no.
Different.
No. May I read it out? একটু stay petition টা দিয়ে দেবেন না? Can one. May I, in the meantime, can I can one?
Which page?
Page 6.
Yes.
Lordship should find G.
Yes.
Meanwhile, the respondent number 1, while addressing a letter to the petitioner number 2, kindly take note because now the documents sought to be disclosed.
Petitioner number 2 is the niece.
Is the daughter, yes. Informed that it had transferred its leasehold right in respect of that portion of the demised premises that was laid out in its favor with the agreement of lease dated 1st June 1982. The terrace flat and not the triplex, to the respondent number 2 with effect from 1st October. Specific case. And it's not a mistake. It's not a mistake. Kindly come to paragraph 38 of the same stay petition.
Drafted this application.
My lord, I will tell your lordship, my lord, everybody knew the actual fact. The plaintiffs were fully aware what they were doing.
not careful when you draft the plaintiff?
The plaintiffs were fully aware, my lord, what they were
Draft
doing.
the application for stay or something.
No, kindly come to, my lord, page 18, 1-8.
Just 1 minute.
Paragraph 38.
No, I was looking, sometimes it so happened that these are the sub-paragraphs. They wanted to reiterate what you have stated in your
No,
petition.
no. Yes.
So
Yes. Yes.
that I really wanted to, but at
No.
page 4,
I checked
page
it.
4 is a damaging one.
Page 18,
Page 4,
Yes. Yes.
page 4,
It starts the facts. Yes.
from where?
Yes.
From where? Page 4,
From the plaint. Yes.
the said suit was preceded by the following fact that the
Yes, that's true. That's true.
yes.
Now, my lord, kindly come to page 18, 1-8. A confusion was sought to be created that, look here, they are paying 13,000, so it cannot be the triplex flat. Kindly come to page 18, paragraph 38. Your petitioner states that recently the petitioner has come across such and such, issued on behalf of the respondent number 1 herein, demonstrating that the respondent number 1 used to pay a monthly rent of rupees 13,000 for the purported terrace flat, notwithstanding the actual monthly rent fixed rupees 500 for that portion of the suit property. Leased with a agreement dated 1st June 1982. There is no confusion. See, it transpires from the aforesaid document that prior to its alleged transfer of leasehold right in favor of respondent number 2, the respondent number 1 had been paying rent of the entire. Then kindly come to the next paragraph. Not the end of it. 39. The petitioner states that while the proceedings before the learned civil judge in this case number was pending, the petitioner herein, despite exercising due diligence and employing best of their faculties to rummage through old records, evidencing that the respondent number 1 had been paying a sum of rupees 13,000 against the purported terrace flat, since the lease agreement dated 1st June 1982 failed to produce such records.
These documents are all pertaining to 82.
All these statements pertain to, my lord, the lease agreement of 1982, and which is terrace flat, and they mentioned this. This is also there. That is exactly why, my lord, I wanted to show your lordships the memorandum, because that is their challenge. That is why my memorandums are filed. Kindly once look into the memorandum. What is the case? What they have tried to say in the memorandum. Kindly once take up the memorandum at once. Three grounds. Memorandum. Oh, this is affirmed by the mother. The plaintiff number 1. This petition.
Page 20.
Page 24. I have checked it. 26, sorry. I Shoros Thakkar, aged about 86 years.
And also on behalf of the daughter.
For herself as well as on behalf of her daughter as a constituent. Now,
No confusion with regard to the
না confusion এর তো প্রশ্ন আসে না. Kindly once take up, my lord, the grounds. The memo.
same documents will be used.
And these same documents have been sought to be relied on in, my lord, the application under Order 41, Rule 27. I can show your lordships that not through rummaging of papers, somebody else gave it. ভাইয়ের কাছ থেকে পেয়েছিল বলেছে?
After tick mark power.
Once the document is undisputed, the custody.
No, these are all disputed.
You have to challenge it.
Now,
Custody becomes the immaterial.
kindly come to my lord ground number 4.
মেমোটা কোথায় আছে? Is it not included in compilation?
Why?
Not to be included?
No. Memorandum compilation to memo neyi? I'm sorry, I missed it, my lord, if it is there in compilation.
No, no, the
801 third version.
আছে? Sorry, it's possibly there in the third volume, but
anyhow shows.
yes. Kindly come to my lord page 3. ঠিক আছে, পেয়ে গেছে? Ground 4, kindly come. For that, the impugned order was passed basis the concocted case of the respondent number 1 that the suit property mentioned in agreements to lease dated 1st June 1980 and 1st June 1982 were distinct and separate from each other. They are saying that these are distinct. Kindly come to the next ground. For that, notwithstanding the lease agreement dated 1st September 1980 and 1st June 1982, the terrace portion of the suit property as referred to in the lease agreement dated 1st June 1982 was never demarcated or made separately identified. No such case has ever been made out. Kindly come to next ground 7. For that, the learned civil judge failed to appreciate that there was no document and or evidence before the learned court either during the suit proceeding or execution proceeding to show if any portion was carved out and deemed as separate and distinct from the suit property. So a desperate attempt makes them together get the decree executed. They knew that only the terrace was given, so that has to be mixed up. Kindly one more ground, my lord. 18. For that, the learned civil judge failed to appreciate that title suit number 57 of 2008 was instituted upon a notice to quit, which was served on the respondent number 2 on the basis of the fact that the petitioners herein were informed admittedly by the respondent number 1 that its leasehold interest and possession was transferred to the respondent number 2, and the latter would pay rent directly to them. Yes, terrace flat, not the triplex. And sorry, one more, my lord, 31. For that, the respondents number 1 and 2 are absolutely connected to each other and have been occupying the suit property since prior to the institution of the title suit, being number such and such, without payment of any rent to the petitioners. So I am in possession.
Can a ground be treated as an admission on their part?
No, I am not saying that. These are the challenges.
So
That is why
verified, it is neither verified, nothing. It is
The
merely a
petition
challenge to be done. On the proposition of law, one may accept, one may not accept.
same allegations are, my lord, at a time, my lord, when I was young, my lord, I never used to, my lord, include the grounds of memo in the stay petition. Now, my lord, fortunately or unfortunately, the grounds contained in
Civil divisional application.
grounds contained in the memo are, my lord, given in the stay petition also.
50.
And is and are affirmed.
53.
These are there.
53, sir. 53.
From where this practice has developed?
I do not know, my lord. I was lazy. That is why I did not use to, my lord, incorporate all these grounds again, because at that point of time, everything was required to, there was no cut paste system. So I had to dictate everything. To reduce my burden, I never used to do that possibly. But now I find that the grounds are all incorporated in this deputation.
Make it more bulky.
53. Stay petition. Same.
অন্যগুলো আছে? Yes. Ground 31 is paragraph 53. The other allegations are also there
Of the stay petition.
of this deputation. Now, my lord, on transfer ওইটা কপি আছে? না না, ওটা না, ওটা now on privity of contract and privity of estate, well, it was
No, I invited the trouble.
no, I have relied on two decisions. I am grateful. We are grateful. Now, it was submitted that the assignment was with consent. No. Assignment with consent, my lord, presupposes that the consent has to be before, or it has to be a tripartite document. It can happen in two ways. One, yes, I'll tell you, lordship.
On tripartite and another,
The other is a prior permission. It cannot be that I assign and then merely because I go on paying, or the assignee goes on paying rent, my lord, that is consent. That is exactly what, my lord, this Transfer of Property Act Mulla says. Kindly look into the
what is the language of section 108G?
পাত্রাটা দিন না। আমার তো বই ফই আছে, দেয় না।
কি একটা আছে এখানে?
মর্টগেজ ফর সাবলিজ রেজিস্টার করতে হবে।
দেখো এখানে বার করতে দিয়েছে। Where does it require a consent? 108J.
No, it was submitted. The Mullah was relied on a page from Mullah.
He wanted to say that there are two, he wanted to distinguish these two judgments on a score that both the cases, there was a unilateral act. When it is not a unilateral act, and the lesser has accepted what I understood from the argument,
Very well.
and the lesser has accepted the assignment or a transfer, then in that event, it loses the character of a primacy of the privity of contract, because it blended both the privity of contract and the state into an assignee. This is what they really wanted to say.
Well, let kindly,
And therefore not obliged to make the assigner as a party for the sake of the evidence. So Mukherjee tried to say that.
kindly take up the Transfer of Property Act. The Mullah.
Does not talk about any prior consent or something.
No, on the contrary, it goes on to say, mere acceptance of rent from the assignee by itself, it is submitted, is not enough to release the lessee.
No, that is what the Mullah's comment comes.
Yes.
The language of section 108J does not suggest. It simply says that the lessee may transfer absolutely or by way of mortgage or a sublease
Yes.
the whole or any part of his interest in the property, and any transferee of such interest or a part may again transfer it. So it's a recurring one.
Very well.
The lessee shall not, by reason only of a transfer,
cease to
subject to any of the liability attaching to the lease. Then there is a clause. Nothing in this clause shall be deemed to authorize a tenant having an untransferable right of occupancy.
Yes,
The farmer of an estate,
yes,
in respect of which the default has been made in paying revenue, or a lessee of an estate under the management of the courts of law, to assign his interest as such tenant, farmer, or lessee. What he want to say is that in case of any breach having committed of a lease, then definitely it's the obligation of the lessee, despite he having assigned his interest in favor of another person. His liability
continue.
to remedy the act or the breach remained. But for the purpose of securing an eviction, there is no obligation that the assigner has to be made party when there is no element of any breach of the terms and conditions. Because the suit is purely based upon expiration of the period given in the notice under section 106.
May I, my lord, now?
If I correctly remember.
Yes, yes, yes.
106 notice, period expired,
Before that,
you have no right,
before that.
which is one of the ground under section 111 to come to H, 111H. It says that on expiration of a notice to determine the lease or to quit out of intention to quit the property lease duly given by one party to the other. That's the ground on which it is based upon.
One party to the other, party to the lease. One party to the other is a party to the lease.
Question is, once the assignment takes place, then the assignee really step into the shoes of assigner.
Kindly bear with. Lordships have seen the language of J that, nothing in this clause shall be deemed to authorize a tenant having an untransferable right of
Different. That is in case of a Thika tenancy, if you say it's not a transferable right.
Yeah.
Under the Bengal Tenancy Act, there is that you can't transfer.
This transfer, the assignment was firstly by an unregistered document. I ought to have come with that decision, our division bench decision, which says that any right in an immovable property, assignment of any right.
I give you a Supreme Court judge.
No, I
see it is.
Yes.
Vishwani Properties Limited. If I correctly remember, AIR 1980 Supreme Court.
Our division bench was before that. Now, be that as.
Vishwani Properties. Or
now, that has to be by a registered document.
That was a case of the surrender or novation or any variation. Once it is a registered document, it can only be varied by another registered document, not by a registered document.
The division bench I have in mind, it's a division bench I definitely remember, reported in CWN. I don't remember the year or the volume of the page, but it says that an agreement to sell, unregistered agreement to sell, if it has to be assigned, the assignment has to be by a registered document.
Obviously, because it is affecting an immovable property.
Absolutely.
More than 100 rupees value.
Absolutely.
And it is a compulsorily registrable not only under the TP Act but also under the Registration Act.
And this assignment took place before my lord 1997 Act came into force. I don't think that we are required.
You are opening another avenue for that.
No. I
never assigned my right in respect of this property. It may be at risk for a terrace flat, which is distinct under the 1982.
Well, I did not try to do this. I did not try to do this. Since all these questions came up, my lord, I made this submission.
So you wanted to,
No, this is a legal position. I did not try to. I made out my case.
the case was as simple as
Absolutely. Terrace flat, triplex flat.
one is covered.
Assignment of
One is covered under 80, the agreement for these or.
the other one is 82.
82. So according to you, maybe 82 has been assigned, but not 80.
No.
I am concerned with 80.
And they
That's a simple case.
absolutely.
In the garb of a decree, you can't be evicted. What your case?
My lord, my erstwhile directors, they have secured their position. They have secured their position in respect of the terrace flat, which is now a complete flat. Join hand with the landlord. Throw somebody else out. Secure my position. That's the game plan. And the landlord is also happy he is receiving, my lord, 3 floors in this process. His hard evidence, I have shown your lordships, hard evidence is it is triplex flat. It is terrace flat. I had shown your lordships a cross-examination.
Stay petition clearly बोली थी 82
And stay petition now, finding the difficulty in the stay petition, they now say, yes, it's 1982 document. That's it. Terrace flat.
But still in a precarious position.
That, my lord,
More better.
my lord, I have a limited role to play, my lord. I am trying, me personally, my lord, I am trying to distance that. Or we, I would say, for the time being. If my lord situation ever occurs, my lord, if we have answered, my lord, if required, we shall disclose that. ভেবে রেখেছি now, my lord, to cut short now the decisions. My lord, the first decision relied on by them is, my lord, reported in 2005, volume 2, Supreme Court cases 247. That is, my lord, about the affidavit found by constituted attorney. My lord, I have shown, my lord, they have taken the point, made application dismissed, not challenged. And that is not a ground in this appeal. They possibly could have done that. That is not a ground in this appeal.
suggestion of the
Yes, no suggestion. And as I said at the very beginning, at least, my lord, carapiet, applying the principle of carapiet, whether, my lord, carapiet applies or not, my lord, principle of natural justice, my lord, applies. My lord, in arbitration, my lord, often, my lord, the arbitrators say that, well, carapiet does not apply. Why are you giving suggestions? That once I had to say, yes, carapiet may not be applicable strictly, but principle of natural justice. If I don't give the suggestion, how would they know that this is going to come subsequently?
Justice and good consent.
Absolutely, absolutely.
Natural justice.
Natural justice.
Justice and good consent. Because the section itself in arbitration says Evidence Act
Absolutely.
will not apply, or for the simplicity of will not apply.
of essential justice.
Rule of essentials. Thank you, Your Chairperson. My lord, the next one, my lord, they have relied on is reported in 2024 volume 6 Supreme Court cases. 660. 130?
Yeah, 160.
My lord, they have relied on two paragraphs, 28 and 29. আরে অনুজ এটা কে জোগাড় করেছে? Yeah. 28 and 29, but before that, kindly once come to paragraph 24. The plaint was filed and verified by so-and-so who has not entered the witness box. To substantiate the pleadings as to for how long he or his predecessor had been using the said rasta for egress and ingress to the land before, etc. Now, as I have already submitted before your lordship, my lord, this suggestion was not given that you are incompetent, and he had himself, my lord, verified the application.
Dismissal file করেছিল, which has been rejected.
Dismissal filed, rejected. And then paragraph 28 and 29, they have relied on. The law as understood earlier was that a general power of attorney holder, though can appear, it's not a general power of attorney holder here. Though can appear, plead and act on behalf of a party he represents, but he cannot become witness on behalf of the party represented by him, as no one can delegate the power to appear in the witness box to another party. However, subsequently, in Janki versus so-and-so, this court held that the power of attorney holder can maintain a plaint on behalf of the person he represents, provided he has personal knowledge of the transaction in question. It was opined that the power of attorney holder or the legal representative should have knowledge about the transaction in question so as to bring on record the truth in relation thereto. Now, this person is not representing an individual. He is representing a company. The company cannot come to the box. The company has to be represented by someone.
Some natural person.
Some natural person. That is exactly what has been done. And that is why there was no suggestion, no denial of those facts. Either in their affidavit in opposition to my application, the objection, written objection to my application, or in cross-examination. On the contrary, in cross-examination, questions are put on those documents, the two lease agreements. Now, well, the next one they have relied on is the 1980 supplementary SCC 417. Appreciation of evidence in a criminal case. Owner says, well, not something different.
Applied in a civil case of a division bench judgment of a
Different. Civil case, it has relied on.
Yes.
It's a criminal case where, well, this does not come into effect. Well, the next one is reported in 2005 for CHN.
This is what justice said that
Yes,
where this judgment of 1980 was accepted and retired.
I shall come.
I correctly remember, the justice said
Yes, yes. Paragraph 7. Kindly come to my lord, paragraph 7. May I read out? Admittedly, the judgment under review had proceeded to believe the evidence of the wife on account of absence of cross-examination on the question of cohabitation. Absence of cross-examination does not mean that the evidence is unchallenged. In such and such, the apex court had held that the cross-examination. Sorry? Yes, yes. 81 Supreme Court, AIR 81, that is valid.
1980 supplementary.
Yes.
Contrary to proceedings.
In such and such, the apex court has held that the cross-examination is not the only method of discrediting a witness. If the oral testimony of certain witness is contrary to proof facts, why? It's not required. My lord, my lord, lordship has done it. Number of suits, I have done some. Occasion arose, my lord, when we say cross-examination declined. Because the witness has not proved anything. Here, my lord, it cannot be said that, my lord, my witness did not prove its case. Their evidence might well be discarded on that ground. If their testimony is on the face of it unacceptable, courts are not bound to accept the testimony merely because there was no cross-examination. Similar view was taken by so-and-so, where it was held that the cross-examination of that witness, it was held that the court is not bound to accept the statement of a witness simply because there was no cross-examination of that witness. The truth of the evidence is to be tested on the basis of probabilities and reliability. Now I rely on their case. They themselves say that their cross-examination, plaintiff's cross-examination said, firstly, the document they relied on, undated letter, it says terrace flat. The witness of the plaintiffs say that letter of atonement was given in respect of the terrace flat. They had relied on the document.
Stay petition which is 1st June 1982.
And I have shown now, my lord, the stay petition, 1st June 1982. Now, needle industries. 81-3 Supreme Court cases 333, paragraph 63. Well, it is a matter arising out of section 397, 398 of the Companies Act, where matters are decided on affidavit.
Paragraph 63.
63 দেখাচ্ছি। May I read out paragraph 63? We appreciate that it is generally unsatisfactory to record a finding involve a grave consequence to a person on the basis of affidavits and documents without asking the person to submit to cross-examination. 397, my lord, I distinctly remember occasions arose when, my lord, the court said that no, it has to be tried on evidence. Operation means it has to be tried on evidence. It is true that men may lie, but documents will not. And often documents speak louder than words.
What he wanted to rely upon this, that once the documents are there, and if the document is pitted against the oral evidence, then what Mr. Mukherjee says, it is a document which will
be
louder than the oral evidence.
Look at the document at page 70.
What he says that look at the documents. If the documents are galore, that it is relatable to this, then question of giving an oral evidence, not giving an oral evidence, does not arise. It's the document which will take primacy.
Documents,
But that is an ES cycle.
very well. Documents before the court. Which documents? Page 70, undated letter, the two lease agreements.
No, that you want to distinguish that their own stand is that everything has to be the document. If there is any ambiguity or any question of more than one interpretation comes from the document, then the surrounding pleadings can also be looked into in order to find out that what the parties intended. Because the only question which is required to interpret a document is the intention behind writing those documents. If the intention can be gathered from the other surrounding evidences, which is also a pleading, according to you, then it is clear that what it speaks. Does it speak for the 12th, 13th, and 14th floor flat, or it speaks for only a terrace floor flat, which is really on part of the 13th floor?
May I read out only one portion?
So he relied on this sentence.
Very well. Here, my lord,
Document speaks louder.
may I read out one portion? The learned appellate judges of the High Court have observed in their judgment that it was admitted that before the learned trial judge, both sides had agreed to proceed with the matter on the basis of affidavits and correspondence only, and neither party asked for a trial in the sense of examination of witness. The parties agreed and it proceeded.
Principle is correct.
It proceeded.
Principle laid down in this judgment is correct. If the document is there, it will speak louder than the oral.
The document as explained by the parties witness.
As
There-
understood by the party.
As understood by them. As understood,
Understand differently, you may understand.
as understood by the plaintiff number one, the mother, that when a terrace flat was let out. I mean, assigned. Or key. 22. Oh, huh. On order 41, rule 27, my lord, 2022 volume 7 Supreme Court cases 247 was no. আমায় এই দে তো 12/8 আর 7/14 12/8 আর 7/14 2022 7 Supreme Court cases 247, my lord, was relied on paragraph 7, 8, and 9.
If the court requires the document for effecting,
If the
I don't know. I believe that you are not going to dispute.
no. Absolutely. If the court finds that on the basis of the evidence on record, it is unable to pronounce, my lord, then the question of, my lord, seeking additional evidence by the court arises. ছিল নেই ছেড়ে দে। হ্যাঁ remand. And my lord, yesterday, my lord, a question arose about remand. My lord, lordships are aware, my lord, she have done, my lord, or dealt with matters. Order 41, rule 23 onwards, my lord, remand, my lord, is an exception.
The appellate court will take an evidence and decide it.
Can, if required, if the evidence on record is sufficient to dispose of, my lord, the appeal court is not required to even do that.
There are three modes. Under order 41 to 23, 23, and 24. There are three modes of a remand. One is the court can remand the matter The trial court
So
decided upon place either by screening, which is a limited remand, or an open remand.
Yes.
Second, the appellate court himself can take an evidence and then decide. Or third is the appellate court can remit the matter to the trial court, permitting the parties to adduce evidence, and then the evidence to be given with the findings thereupon, so that the appellate court may decide. These are the three courses which is open to the appellate court.
kindly, my lord,
Look at the letter.
kindly consider 23 and 24. Yes,
I'm saying, yes, Order 41 Rule 23, 23A and 24.
Lordship. One decision, my lord, may I hand over copy, my lord? It's, my lord, reported in 2023 SCC Online Supreme Court 196. Basically, my lord, paragraph 20, copy dena re.
দিয়ে দিচ্ছি ওদের দিয়ে দিচ্ছি আপনারা
Paragraph 21 onwards, my lord. Twenty-one, my lord, 22, 23, my lord, sets out the provisions. Then 24. While explaining the scope of Rule 23 and 23 of Order 41, in the case of municipal corporation, this court has observed as under a distinction must be borne in mind between diverse powers of the appellate court to pass an order of remand.
In conjunction or the juxtaposition with Order 41 Rule 33.
আর কি এত কিছু নেই হ্যাঁ হ্যাঁ ও yes, my lord. I should point out, my lord, the judgment your lordships, my lord, were pleased to rely on yesterday, or my lord, indicate yesterday. On Order 41, Rule 27, my lord, that additional, my lord, which is reported in AIR 97 Supreme Court 3243, my lord. We tried to find out, my lord, there is not even referred to, but there is none. এটাতে কিছু নেই এটাতে কিছু নেই ওই একটাই ছিল
Binding on us.
provided the court requires.
That is what is always there.
Yes. My lord, those are my instructions.
Conclude.
Yes.
Let Mr. Can it be kept tomorrow? Let Mr. Mukherjee would make
How long
submissions.
will it go? The difficulty is that I have only a very, very scanty time.
কি আছে নতুন নতুন রিপ্লাই দিয়েছে
Only a-
reply.
Only on this order which has been placed today, Mr.
The matter of record.
They ought to have listed. আমি বলিনি বেশি
They have said that you took out an application. The applications were rejected.
এগুলো তো দেবার
The grounds you have not challenged. That order is also not challenged in the instance.
না না
So which we get, there's no difficulty. Under section 105 of the Code of Civil Procedure, you can challenge. If you did not challenge, that means that it attained finally. So this is what this
Hey,
is.
Baba.
Yes,
Now, it is the day to contain that I have no authority.
but it gives us,
But contention of Mr. Mukherjee was, that's not a question of authority or no authority. The fact which is not within the personal knowledge of the knowledge or constituted
My lord.
then he is incompetent to
yes,
that he has reacted that look, it's a company, it's not an individual. And the company cannot come because it's a juristic person, must be represented by a natural person. So he's a natural person and he has come forward and adduced everything. There's no illegality.
that's the reply, my lord. Yes, my lord.
Both cases I said, both ways. Your stand and then their
Yes,
stand. So as a third person, we have to accept which side of the coin is heavier and which is not.
yes. My lord. But I would only beseech, my lord, give us 10 minutes tomorrow, my lord.
Reply. Not
Oh.
even in reply. তোরা আগে বলিস নি আমি পরে বললাম I said যে পরে
Because the difficulty is still is fresh. I can start dictation today. I can finish it by tomorrow. If you start, then 15 days I will not be here. By this time I may.
I can do one thing, my lord. I have relied on only one new judgment. I can, my lord, discard that on remand.
My lord, not only on that judgment, my lord. My lord,
Not on
these
that
aspects, my lord,
not on
kindly
that.
gives us 10 minutes.
He took the point, then he says that look, the record speaks otherwise. That he is entitled to under the reply. He's entitled under the reply. It's not a new fact which has come.
My lord, we are in any way entitled to rejoinder, my lord.
And then he says that the plea is not tenable, look at the facts of the case. These are the facts.
Yes, my lord.
Nothing.
My lord, 10 minutes in rejoinder, my lord. Because, my lord, this aspect has to be dealt with, my lord. My lord, since he has been addressing, my lord, kindly gives us 10 minutes, my lord, before my lord starts dictation tomorrow, my lord. Just before my lord can.
Because how much time is left for me? Only today, tomorrow, and day after tomorrow. Then 15 days I will not be.
Yes, before my lord starts dictation tomorrow, gives us 10 minutes, my lord. That's all. My lord, that's all I humbly beseech, my lord.
Dictating in the chamber, not in your presence. I know. I had a bitter experience now. The moment I start dictating in the open court, lot of interruption, interjections, everything comes.
My lord, kindly will permit me to reply briefly to what my lord has been said today, my lord. In rejoinder, my lord. 2 points that I wanted to make, my lord. Yes, my lord. The pleading which has been shown in the CAN application, my lord.
Yes.
My lord friend is relied on paragraph G of the CAN application, my lord. My lord has seen at the start of the paragraph, my lord, the sub-paragraph started with a prelude that, yes, my lord, that the averments made in the plaint were as follows. Now, my lord,
The suit proceeds on the basis
on the,
of those
yes,
facts.
and then, my lord, after narrating the contents of the plaint, my lord,
I have seen that.
my lord, what I want to indicate here is, my lord, that paragraph, my lord, is an error and is not evident from the plaint case, my lord. So, my lord, whatever was there in the plaint case was sought to be narrated in those sub-paragraphs, my lord. This averment at paragraph G was not there in the plaint, my lord. This is, my lord, that's an error, and this, my lord, should not be taken against because the plaint itself is on record. My lord, I take the responsibility, my lord.
Careful drafting.
Yes, my lord. My lord, I take the responsibility, my lord. But fact remains, my lord, that averment was not part of the plaint, my lord. So, my lord, kindly, my lord, that aspect of the matter, my lord, kindly bears in mind because I cannot improve or something, my lord, which is not there in the plaint, my lord. The plaint did not proceed on that premise, my lord. One. Second, my lord. Second, my lord, the second point taken was, my lord, that, my lord, the order challenging the authority was not challenged, my lord. My lord, if my lord takes the order, that order reads, my lord, since the appellate court had directed the deposition to be recorded within time, nothing on the merit.
These are the findings. The ultimate decision is the rejection or allowing. If the rejection has come, the findings may be faulty. But ultimately, the fact is that that it has resulted into a dismissal. Then in that event, one has to understood that what is the effect of that dismissal. One can give reason A, another can give reason B, another can give reason C. That does not mean ultimately affecting the ultimate decision.
Yes, my lord. The only point that I want to make here is, my lord, the order did not rule anything on the merit, my lord. The order said the appellate court had directed the trial to be done immediately. I'm rejecting.
We have to consider it.
Yes, my lord.
Was it
Nothing on merit, my lord.
Was it on a technical ground or was
Yes.
it on a merit? If it is on merit, the one consequence is on a technical ground, another consequence.
Yes, and my learned friend had also argued that I had not taken this as a point in my memorandum of appeal. My lord, it's a factual thing, my lord, I cannot improve, but my lord is aware of Order 41 Rule 2. My lord, with the leave of the court, I can always argue it because this goes to the root of the matter. And also, my lord is not bound by the memorandum's ground. My lord can always go beyond.
105. Read 105. You are arguing something without knowing 105 power.
My lord.
It's not so easy, sir.
My lord, I was only.
In the preamble, you have to say, where is the importance of procedure? Give it to him.
My lord, I have.
Yes. 105.3, I believe. Subsection 3. Or 2, whatever. Yes, it
105.2, my lord.
2.
Yes, notwithstanding anything contained in subsection 1, where any party agreed by an order of remand.
No.
100.
For that. Oh. Nowadays, again, my memory is going. Yes. One itself is there. One. Save as otherwise is provided. No appeal shall lie from any order made by a court in exercise of the original or the appellate jurisdiction, but where the decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground for objection in the memorandum that you have not done.
All that I was humbly submitting, my lord, that my lord can always consider under Order 41 Rule 2, my lord, has enough powers to even look beyond. Yes, my lord. And my lord will also keep in mind the additional document that we have disclosed in Order 40, because that really, my lord, removes any kind of doubt that, my lord.
That is said,
Yes, my lord.
a terrace flat and an open terrace flat.
Open terrace flat.
I know. That is there in my mind.
My lord, kindly keep those in mind, my lord. Yes.
Because they are the directors, they have been involved in all.
And fact that, my lord, the most competent person, Mr. Arya, did not come forward to, my lord, in the box, my lord. My lord, this person not being competent at all, my lord, had no. My lord, those were.
He has countered that with this. That's all. That's all. Yes. Judgment reserved.
Number 15.
I am for the writ petitioner respondent, my lord. Yesterday the matter was called and your lordship.
But he was there.
Yes.
He was there.
My lord, Madhumita Patro for the appellate.
So we were going to dictate the order. Then
Yes.
Then it was pointed out.
There was an interim order, your lordship.
Yes, the Passover because she was there. So
You will kindly fix at 2 p.m. I will call.
can't see at 2 p.m. Yes, call the next.
16. 17. 18.
19,
My lord, I appear for the respondent petitioner.
18.
18.
It's the appellant.
Appellant is the
Pass
state.
over anyhow, 19.
19, 20,
15 days. Lord, the appellant advocate has come.
This call from 15.
Time for the read petitioner respondent. And for the applicant also. Kindly also see the order.
Just where is the law?
Two 18(3).
Where the property is situated?
Number 16.
What are so many applications?
Yes, my lord, I'll blood. Your lordship takes the list of the applications, my lord. I can cut short the matter. Sorry? আগে বলে নিই যে কোন অ্যাপ্লিকেশন গুলো 20টা অ্যাপ্লিকেশন আছে May I just?
You prepared a chart.
Yes, the chart is not before your lordships. Blood, কি দিয়েছিস first for? I'm told blood on the last.
Not these to us.
Who got it?
That was a chart দিয়েছে।
দেখলে আমি সেটা
এরকম দুটো পাতা
নিয়ে এনজয় করতে পেরেছি ভালো দিদি গেছে
দেখো এটা ওই চার্টটা দিয়েছেন কোথায় আছে আরো where is the second judge's
আমাকে এটা দেবে
first আমার
দাঁড়া এক সেকেন্ড আগের দিন দিয়েছে আগের দিন দিয়েছে
কাকে রাহুলকে
বক্স করা আছে এটা এর বদলে এখানে সেকেন্ড জেস কপিটা থাকবে না কেন
পেজ আমার টার্ম বেরিয়েছে 20 টাকা তো এসছে কোড আসে
can 6 has already been allowed.
yes by
Can
order
7 is also
disposed of
Now,
so can
position is there.
lordship
Application for repair is there.
lordship
Then can 15 disposed of, 16 disposed of, 17 is addition.
this is lord, it is not my
Madam, can
Right.
not say it is of disposed of হয়ে গেছে দেখো at the very outset
আমাদের
fine from the
14 ফাইল
Who has filed?
ক্যান 14 তোর কাছে আছে কপি আছে ক্যান 14
ক্যান 14 এর কপি আছে?
কপি তোর কাছে ক্যান 14
না,
কপি আছে
না।
কারোর কাছে
কে
নেই।
ফাইল করেছে সেটাই বুঝতে পারছি না।
তোর আগে ক্যানটা বার করুন
ক্যান 14 মানে হচ্ছে পুরোনো
Applicants are Joydev Kumar, Vikram Kumar, and Boisali Kumar.
আমরা জয়দীপ কুমার,
Are they a party?
তারা তো ওরা তো পার্টি নয় মনে হচ্ছে
জয়দেব কুমার,
পরবর্তীকালে ওরা অ্যাড হয়েছে।
ক্যান 14টা কোথায়?
অ্যাটলিস্ট ক্যান 20 তে তো ওরা পার্টি নয়
This is CAN 4359.
4359 2013.
I'm surprised that names, are they a party already added?
So
to the
then
party?
they were after that they were added as parties. Lordship sees my lord's memorandum of appeal. There was an order, my lord, by which they were added.
Memorandum to the memo to the.
Page is 459. Or instructing advocate কোথায়? এটা বলেছে বাউন্ডারি ওয়াল তো আমরা দেখতে পাবো। হ্যাঁ,
এরা পার্টি আছে কিনা মেমোরেন্ডাম আসছে
আপাতত দেখো
বুঝতে হবে তো
459 পেজ কে ফাইল করেছে সেটা
Sir, from where you got this, the name of Joydev Kumar?
জয়দীপ কুমার
যদু কুমার তো বরাবর
Whether substitution was allowed?
হ্যাঁ
Joydev Kumar was 3 Joydev Kumar was defendant number 3
Joydev is a husband.
Joydev was originally defendant number 3 in the suit
Was there.
মালো
But he was a husband. He's a husband of Shukla. She was brought subsequently along with Vikram and Vaishali.
lordship
Now, what do you want, sir?
জয়দীপ কুমারের কি
কুমারদের হয়ে আপনি অ্যাপিয়ার করছেন
জয়দীপ
কুমারদের হয়ে আপনি
Kumar Patro.
My London friend is appeared. I am not
দুই
appeared.
তিনজন my lord we are appearing for Joydev and the added respondents.
The added respondents were, I do not know, Vikram Kumar, then
Yes, my lord.
Shukla Kumar,
Yes my
and
lord.
Vaishali Kumar.
My lord.
Shukla probably died.
Yes my lord.
Then Joydev is a husband of Shukla.
My lord. But my lord, with respect to this application, I really, my lord, don't have any, I don't even have the papers about it. And I don't have,
When the said boundary wall.
Of the
Now,
boundary
it was
wall.
done in 2013.
13. I have,
Then it has become infructuous. 2011 years, 12 years have gone.
12 years have gone.
What permission to repair the boundary wall?
Right. We have not even looked in, my lord, I don't have a copy of the application.
Please to allow this application with an order to permit the applicants to repair the said boundary wall of the suit property and to restore the boundary wall in its original position by repairing, reconstruction. Now, 11 years, there was nothing. What remained now?
Offhand, very difficult for me to,
And we are dismissing it. Dismissing.
I don't know
my lord, if it's dismissed, I was wondering, my lord, that whether তখনকার
Repair. What is
dismissal
the
আজকে হতে পারে নতুন
lordship
করে।
kindly
possible? What repair?
Status quo.
but there was an order dated 16th of October 2020 on CAN 18 which was also an application for repair of the boundary wall on the second
was
page
allowed.
of this was allowed
Allowed.
So, my lord, if that was allowed, Lord, I do not know the purpose of why my
Probably
lord.
that's why the earlier application was not
Can
moved any
14 is, Lord, should be kept alive.
No.
Which was the application?
The next
Can
one.
18
Can 18 take one, that was the-
and disposed by 16/10/2020 order.
Dispose of exactly same. Dispose of what dispose of.
Old number.
Old number ta,
There is the list.
can 18 এর old number টা কত রে?
Old number.
9631.
Lord, looks to the order dated 16th October, my lord, 2020. 16th October.
No, 2020 হবে।
My lord, kindly looks to the order of 16th October, if it's possible, my lord, because
হ্যাঁ এটা ক্যান 14 হলো 9631। আরে দেখে নিয়েছি কিন্তু 2019 বলছে তো ওটা।
না 2020-তে অর্ডার হয়েছে, দেখো না।
এটা তো 2013।
No, no,
দশটা জিজ্ঞেস করেছেন 2013 ক্যান কত?
Taken out by, this can 18 was taken out by Krishna Das and Dorothy Das.
সেটা কি? এই যে এইটা। এটার কথা বলছি।
They talked
না
about
জজ সাহেব
the-
ওইটার কথাই
the
বলছি।
boundary wall.
Well, that was by
That was
my
Lord
senior
can
friend.
16, that was Lord can 9631 of 2019
না দাদা 18
না তারপর
দরথী দাস কৃষ্ণা দাস তোমার মক্কে
ক্যানটা হলো এটা 2019 এর পরের ক্যানটা হলো 2020 দুটো বাউন্ডারি আছে
can 18 of 2020 is by the appellant if I'm not mistaken.
Right.
Told you two names.
My lord, Krishna Das.
KTB.
Krishna Das.
Yes. K3B. 3A is Krishna Das and 3B is Dorothy Das.
ওটা তো আমাদের মক্কে
They are appellants. So এইটা লেখাটা বোধহয় ভুল হয়েছে এখানে। 18 of 22 তো ওটা by appellant.
Right. Can 18 টার is equal to can কত নাম্বার হবে? নরমাল নাম্বার কি?
9631
সেটা তো এখানে নেই।
এটাই বোধ
This is in relation to a Calcutta house.
And that was for the recovery of possession.
Calcutta
30
There were
gutters.
two applications for repair. One is can 9631 of 2019 and the other one, my lord, was can 18 of 2020. Both of them were disposed of on the same day of 16th of October 2020. Can 18 and can 16 of
18,
2019.
16, 19. 16, 18, 19.
No, দাদা
Can 16, can
can
19, can 18.
16 can 16 and can
16
18
10 অর্ডারে লেখা আছে dispose.
16-10 অর্ডারটাতে ওই দুটো অ্যাপ্লিকেশন ডিসপোজ অফ
application.
অন্য অ্যাপ্লিকেশনটা অন্য রিপেয়ারিং একটা জজ সাহেব বলছে
লেখা রয়েছে হ্যাঁ maybe 3 applications.
হ্যাঁ
Sir, this is a CAN 19 is also at your behest.
that is for expeditious hearing.
County one of the suit property.
Lord, my can 16 was my application.
CAN 16 was also your application.
That was by the
16 was mine.
respondents. That was by the respondents. I'm the appellant here.
That was at the behest of the applicant number 3A and 3B.
ওটা ভুল করে লেখা হয়েছে তোমার লিস্ট অফ ডেটস এ
Please. This is CAN 19. Now, have you got the CAN 19 with you?
No, my lord, I do not
Okay.
have.
This is CAN 19. Who has filed? Applicant number 1C, humble petition on behalf of.
Yes.
Applicant
3A,
number.
3B. 3A, 3B.
So, look at it. What is the prayer for repair of the boundary wall? Now, look at this. CAN 18.
Repairing of the boundary wall.
Yes, CAN 18.
তাহলে আমার ওই
Who is the applicant?
It's 3A, 3B.
Look at the prayer.
এইটা হয়েছে ডিউরিং পিরিয়ড অফ কোভিড কোভিডের সময়
Please look at the petition prayer.
এইটা হচ্ছে রিপেয়ারিং অ্যাপ্লিকেশন ছিল এইটার সাথে একটা অ্যাপ্লিকেশন করতে হতো এইটা হিয়ারিং এর জন্য দিস ইজ নট ফর রিপেয়ারিং দিস ইজ ফর হিয়ারিং অফ দিস অ্যাপ্লিকেশন
Please look at the prayer of
What?
both the application.
Yes, my lord, here's
Listen to him.
Lord, what he says, Lord, is that CAN 19 is an application for early hearing of Lord the CAN 16.
Look at the prayer.
Lord, I've checked up. I've checked up. Why I say this? To pass an appropriate order for early hearing of the application for repairing of the boundary wall of the suit property, considering the grave urgency. So this was, my Lord, an application at the COVID times, Lord, this was necessary. Because
This is allowed, can 19 is
Nine.
also allowed.
yes, yes.
What remain?
So I don't think,
Yes.
Milord, this application has any,
Then what remain?
nothing remaining.
But this is my application are 20.
Now it has already been repaired.
No,
Yes,
no,
20
not
is
yet.
a different
20 is my
proposition.
Additional part.
I'm talking about this. Can
No, that is already disposed.
তাহলে ক্যান গুলোকে তো তাহলে ডিসপোজ
রেখে
করিয়ে দিলে
দিলে
হয়ে গেল, রেখে দিলে আর কোনো লাভ নেই, দেয়ারস নো পয়েন্ট।
Keep it pending.
ইট ইজ মেরিটে হিয়ারিং করে বেরিয়ে যায়।
তাহলে ক্যান 20 টা শুনানি হবে।
Milord, may I just come back? Milord, give me 5 minutes. I'll just come.
দেখো এটা can
Item number 17, Your Lordship, it's my appeal. A connected mat has been filed. This is an assigned matter. We have applied before the Honorable Chief Justice for assignment of the other mandamus appeal. Mat B 254.
Next.
Much obliged.
Lordship, nothing has been served till date, Lordship.
We have
I find this is
Next. Chal.
obliged.
Your Lordship, Senior Government Advocate Mr. Shuman Sengupta is appearing in this matter, my Lord. Due to some medical emergency, very urgent in nature, he is not here. My Lord, kindly, grateful to your Lordship.
But kindly take this matter, my Lord, next week.
Not this week.
The affidavit of service.
19.
Yes, my Lord, I appear on behalf of the appellant, my Lord. Last occasion, my Lord, I could not submit the affidavit of service, my Lord. This is the affidavit of service, my Lord. But there is a defect, my Lord. The 3 days delay. Section 5 application is I have filed. The order passed, my Lord. 18th March 2016.
Sir, the name of the petitioner number 1 to 34 and 36 to 60 and respondent number 10 does not find place in the cost title of the memo.
Yes, my Lord, the issue remains, Lord, analogous matters were heard. Lord, I have obtained the certified copy. All the matters, I have the certified copy, my Lord, the certified copy of another matter, it has been annexed, though the order is common. Lord, this is the certified copy, same date I have applied for and same date I have received. That is there.
What do you say about
I have no objection, my Lord.
the defect pointed out by the statutory it be ignored? An application for condonation of delay of 3 days in preferring the instant appeal. After perusal of the above mentioned instant application and upon hearing the respective counsel, they are satisfied that the applicant was prevented by a sufficient cause in not preferring the appeal.
My Lord, I am praying before your Lordship.
Therefore,
जो order টা pass করো
the delay in filing the application is hereby condoned. The application, such and such is allowed. Let the other application be listed in the next week.
Lord, subject to Lordship's kind sanction, Lord, I should be bona fide to your Lordship. There is no scope for stay. But if your Lordship allows me, I can file a paper within 1 month.
20.
I am appearing for the respondent number 4. State is not appealing.
But I am appearing on behalf of the state by Mr. Mukherjee, your lordships. But your lordships has instructed Mr. Mukherjee, your lordship has short passover. Code number 4 is the matter going on. Just instructed to me. Short passover.
Matter of 2018. Here, your lordships heard the matter. Practically, my part I concluded. What has happened, my lord, for filling up the post of clerk? Your lordship, without looking into the brief, I can, within 2 minutes, I can, my lord, bless the man. For filling up the post of the clerk, a regular recruitment process was initiated. My lord, twice, thrice, my lord, the matter was moved because the court selection process was defective, and ultimately final order was passed to hold a fresh interview. When a fresh interview was held, and my client, my lord, they secured first position in the panel. The DI took a plea that the relation between the, you lordship remember, that why the secretary was not included in the selected list, the selectors. Then, my lord, the managing committee adopted the regulations. The secretary said, as my relation is one of the candidates who is appearing in the, it is better that I will off from the selection procedures. Now, that was the issue. Now, the DI said that was why he was not included in the panel, why he was remain absent. And so for other concerns, they said this is a curable defect. It is no problem for approval of the panel. This is the only short well where your lordship directed Mr. Mukherjee to take instruction and the further process, whether this after the commencement of the School Service Commission Act came into force in 2009, whether it will come by the School Service Commission Act or it will be the in terms of the old rule. We have prepared a list of dates. The list of dates. Now the impugned order filed by the district inspector of schools on page 49 of the stay application. This court appreciated the absence of the secretary because he should not have participated in
The stand of the state. Lordship, kindly say regarding the impugned order, your lordship passed by this court, your lordship. And your lordships. I am looking at page 49 and 50. That is the order under challenge.
Yes, we got the track.
Yeah, it has put in the due dated 26/12/2003 regarding the composition of the committee, selection committee. Last portion, your lordship, page 50, your lordship, last portion, your lordship. The district secretary was not there, president was there.
Yes, president. That's why the ground taken. Why the president was included? Why not the secretary? May I hand up the room? Possibly there, but
Must be here.
I'm again handing up. No problem.
This is the recruitment rule.
Yes.
Of 2005.
Yes.
Yes.
Rule 6.
Yes, yes.
Selection committee 6B, it is for the clerk.
No, he has quoted at page 50 something else.
Page 50.
Last portion, actually.
Secretary. 1594, dated 26/12/2005.
He has quoted something else. That's why I'm asking. Was there any amendment which has come up?
No, in case if there is a blood relation of any member,
That's not there in the rules. That is what I'm asking. This is conspicuously absent in the rules. That's why I'm asking you. Was there a further amendment?
no matter the further amendment by the no. Subscription Act last year.
জজ বলছে জজ বলছে আপনাদেরই দল
কোনটা এসে তো আমি জানি না স্যার আমার কাছে আমি রেডি না পূর্ব থেকে নোট করে রেডি করেছি স্যারকে সামলাবার জন্য
Word that it is the blood relation. This is not, I am not getting it from the rules.
And was in the room that
I do not know the old one as quoted here. Also,
oh yes, 5A.
5A. 5A.
5A.
5 is what?
Uh, 2, 3, 2, 3, 4, 5. Next page. 2, 3, 4, 5. Suppose. Road 6. Road 6, 2, 3, 4, 5. 5 will also stand in page 418. No person who is related by blood, marriage, or adoption, or to a candidate to be interviewed by a select council act.
There I am not getting it. Oh, this is 5A.
5.
Yes.
This is the only issue. And if your lordship can be happy to
Suppose if he cannot be a member of the selection committee, then what to do? How the president can be wrong?
no, because one that is the stage. Yes. The B, 6B. Headmaster, secretary of the school authority. Provided that if the headmaster and the secretary of the school authority are same and one person, the president of the school authority shall be the member of the select committee.
There is a case where secretary and headmaster are not the same person.
But the secretary is the related.
That's why I am asking. then one has to interpret the statutory provision in a particular manner. What to be done? If a particular contingency or situation is provided,
Yes.
then it will apply to that situation.
Right. But if there is a gap, what can fill up?
What? How?
I
How?
tell you, Lordship.
There is a gap and how it is.
No, well, I tell you, Lordship. Provided the headmaster, secretary of the school authority are one and same persons. The president of the school authority shall be a member of the selection. There.
So, if they are one, then
And your Lordship, kindly 5B. Kindly see the situation, visualize the situation. No person who is related by blood, marriage, adoption, to a candidate.
not know what to do. How is to be, how these provisions have to be organized.
Now, because of the fact, my lord, the secretary is absent because he is the relation of one candidate.
Understand?
Yes.
Purpose of this provision was that the headmaster and the secretary. Master, dependent,
Independent.
and then the fourth one is the nominee of the Panchayat Samiti.
These are the
And these are the three persons.
Yes.
These are the, so there must be an expert must be there. Where is an expert?
Expert is the
He talks about an expert. This is a clerk, group B staff.
Group B staff. Not clerk. This is a post of clerk.
Correct. Headmaster, secretary of the school.
Your Lordship, kindly, rule 5 people, Lordship, kindly have a look.
Then nominee of the Panchayat.
Yes, headmaster, secretary, and thereafter the expert, thereafter nominee of the Panchayat. Expert, my lord, the page, rule 5, 5 Roman 4.
5.
5.
I do not find 5.
Method of the recruitment, life club, improve staff, Your Lordship got it? Rule 5.
Rule 5.
Rule 5.
Yes.
Method of the recruitment. A recruitment of a librarian or a clerk or a group staff of the school shall be made on the basis of the selection directed. 1. There shall be a selection committee for selection of the candidate. Post of librarian or a clerk or a group staff of the school as the case may be. Whenever an objection for recruitment to the post of librarian clerk would be the school as the case may be arises. Selection committee. For selection of a librarian,
We are not concerned.
no, we are not concerned.
In librarian, an expert is there.
Yes. Yes.
But we are concerned with the
Selection of the clerk, group staff. The selection committee shall consist of the following: headmaster, secretary, headmaster of a school is to be selected as situated headmaster of a school, that is the expert, and nominee of the Panchayat. These are the 4 persons are
an expert.
The headmaster of the school of the same subscription as the school is the clerk of the
Six. Correct. Correct. Expert referred to in subclause 4. Where is the referred to in subclause 4? This is in relation to a librarian. ওখানে subclause 4 বলা আছে উপরে that is in relation to a librarian. That is what I'm thinking about. Librarian. The librarian.
Subclause 4 of clause B.
That is the librarian. You will find an expert. Part A, then the clause 4.
The school open. Check that. Other food. Only my lord, submission I can make. If your lordship an explanation 3. Explanation 3. Explanation 3. 6B. What a person.
Where is an explanation? Explanation is appended to nominee for the purpose of sub-rule recognize means recognize.
One. After explanation. 3. Plus 3.
But sir, I had seen, but it is referable to clause 4 of clause A of sub-rule 1, which is for librarian.
My humble submission would be, except that there is no clear language. Except that
no, there is
no
nothing.
headmaster for
The expert
well, I'm
is
putting
not
myself.
required. The expert is not required in case of a clerk or a group D. It is required in case of a librarian, which is a specialized post. And that is why I say that an expert must be a librarian or a teacher of a library science.
Then my lord, that this is the lacuna. Clause 3 headmaster for what purpose? Because of the headmaster is there, selection. Headmaster is.
Please consider on selection of a librarian.
Yes.
The headmaster, who is the head of the school, he has to be there. Then the secretary, because he is in the management, he has to be there. Then it says that an expert should also be there.
Yes.
Why expert? Because the librarian post or the post of a librarian is a specialized post where must have a knowledge how to keep the book, how to arrange the book, how to maintain the entire thing, everything. So an expert will be able to judge whether he is capable of discharging that duty or not. For group D staff, it is not. It's a menial job. So that is why the word expert was omitted.
Yes, if it is omitted, then I have better footing. But not expert is not required.
Is not expired. They are not required.
The headmaster is there.
Expert. Who is an expert? Group D staff expert. Tell me.
Headmaster. No. Headmaster of a school is the expert. Headmaster of a school in the subdivision. If the expert is omitted, then my lord, I am better footing. There is no question of an expert.
My lord, what is
The decision of district expert in school is wrong.
It's not a case of a quorum non-judice.
No.
But it's a quorum based judice.
my lord, I have a submission in this.
So the panel has to go. The entire selection process has to go.
At that point of time, the headmaster was not there. It was run by the teacher in charge. Yes.
Master or a teacher in charge is the
Head of the institute is.
I am just thinking about it. What is the expert business? In group B and clerk.
I tell you, lordships, one of these procedure is followed in every selection process in 1995 recruitment rules, 2005 recruitment rules. The headmaster is being called as expert. I am not minutely check up, just your lordships, my lord.
Your lordship don't know if the rule permits that. I do not know that it should be there. But I find at the bottom of that book which you have handed over, at the bottom you will find.
Yes.
The old sub-rule is reproduced below. What was old sub-rule? Was the nominee of the panchayat certificate, which is omitted. That was in case of a librarian. Then it was, yes. Nominee, the panchayat nominee is still there in that.
Yes, yes, yes. Because the subroute will also take in subroute clause 4 of clause B of the subroute 1 is selected by the school.
Yeah, one headmaster of the school in the same subdivision
Yes.
was also included. He can't be said to be an expert, but he is an headmaster of the another. Yes, a three term. Not a newly set up school.
No, it is not applicable. Newly set up is not applicable.
So what to do? Just tell me.
And my humble submission that the school authority proceeded with the fair. There is no such an allegations, the nepotism, favoritism, everything.
How to reconcile both the problems?
Now, this is my.
I am talking about law.
No, সেটা তো দেখতে হবে, সেটা তো দেখতে হবে। Can it be report called for? Entire expert.
I understand. The word expert is very loosely introduced.
Yes.
It is really an headmaster of another school with its subdivision who was called.
That was there.
That is their case also.
Yes.
It was called. But now, what about this?
Now your lordship can have a look to the
How to reconcile this proviso and this sub-rule 5 or 4? How to reconcile? He can't be the member.
No, he is not the member.
He will not be the member.
Secretary.
No doubt.
Secretary.
Then what? Will it remain with the 3 person?
So most probably your lordship.
It has to be 4 person. And the president is to be robbed in. But the president can only be robbed in if the event is secretary and the master are one and the same.
Lordship, most probably page 50, your lordships. Constitution bodies there, page 50, Roman I, secretary, headmistress, teachers in charge, panchayat samiti.
This rule.
May I suggest one thing?
This. And then say that since the secretary was not there and the president was there,
Yes.
then it is wrong.
The rule says in this situation, if interpretation is required, any about the said rules, your lordships can delegate the matter or can call for the report from the commission of the school. Your lordships can list. 12, rule 12 of the rule. Recruitment rule. Interpretation. If any question arises
of the court.
Yes, madam.
Then what is the role of the court? If everything is to be done.
No, madam, this is the if it is a silent, then madam, what will be
That's why I am asking that what should be?
It is interpretation if the question arises regarding the decision of the district inspector schools. District inspector schools decision is under challenge. So my lord, that portions we overlooked. Admittedly, we overlooked, as your lordship, my lord, the court pointed out. Neither the trial court nor the before the A court. Anyhow, when my lord, it is the first time it is coming, my humble submission would be your lordships can ask for the report from the Commission of the School Education. It's only that portions. So for applicability of the School Service Commission, so far my lord, it will be covered by old rule or new rule.
Easy path to get away with. You don't want to put much efforts into the matter.
Well, I have no role to play. I have to
have a role to play here.
No,
regarding interpretation of the
my
tell me what should we do if there is this kind of a situation.
Lord, may I submit?
What doctrine What is to be applied?
Lord, there are two decisions in this regard. One of this Honorable High Court, three bench judges decision,
What?
where it has been said by authored by SB Sinha. SB Sinha, I'm citing.
Same situation.
Yes, almost like same.
Now, what's the judge?
Where my lord, the principles has been set down at last page, paragraph 32. Paragraph 32.
Copy 9.
The recruitment rules, although contain directory provisions, the same are required to be substantially complied with. Any deviation and departure from the directions issued by the director of school.
Which one you are referring?
Page 32.
Serial number 32.
Page 32.
Last page, para 30.
Paragraph 32.
Last page, para 30.
Last page, paragraph 32.
1, 2, 3.
These are the principles has been decided. In that case, what should be a procedure of the selection? Any deviation and departure from the direction issued by the Director of School Education by reason of the said recruitment rules can only be made by the Director of School Education himself or by the state government by issuing an order or a direction or guideline depending upon the facts and circumstances of each case. And number 3 is the managing committee of the respondent school is bound to follow the provisions of the recruitment rules, and the petitioners having not raised any questions of constitutionality of the said rules in the writ.
Understanding what is.
No, this overruled judgment, my lord.
Yes.
Devashish Dutta was considered by the special bench, Ravindranath Mahata.
You are not understanding what is passing through our mind.
Yes, whether the replacement of president by the secretary.
My lord, one judgment, one
Yes.
Is there, which permits the replacement of secretary or a headmaster by the president.
No.
But this replacement is permissible when both the headmaster and secretary are one person.
But here is different person. Yes.
5A mandate. This sub-rule 5A. That any person who is related by blood, marriage or adoption to a candidate to be interviewed, he shall not act as a member of the selection.
Yes. That's right.
Now, the situation arises where one of the relation by blood of a secretary is a candidate to be interviewed. Secretary showed his, I would say, very fairness and say that he is a candidate. I do not want to be a part of the selection committee. The secretary recused from the selection committee. Then what the school authority you did, you invited the president to be a part of the selection.
But my humble.
And then the interview was held. This challenge is made, the authority, the DI says that how? Because the rule says secretary has to be there. Why you have invited the president? The entire selection committee is back. I will not grant an approval.
The procedure is my humble submission.
What the what procedure? Procedure is laid down here. What procedure?
The Supreme Court decision is also there.
What it says?
The large judgment decisions in Tej Pathak versus Rajasthan High Court.
What it says?
Lord, I am submitting the copy of this decision. So for the
No, decision you are referring.
Yes,
And this has been overruled in a subsequent decision of a larger bench. And
no,
you
no,
are,
it may be, but this is the latest.
now
This is
looking at it.
This is the latest.
Yes, now I remember Ravindranath Mahata.
Yes, yes, yes.
There's not a good law. And you are citing an overruled judgment.
No, that is why maybe. But this is the latest judgment of the Supreme Court. Will not kindly come to paragraph 5. Paragraph 5 of page 10. In various judicial pronouncements, the law governing the recruitment of public services has been colloquially termed as the rules of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an oft-quoted legal phrase that the rules of the game must not be changed midway or after the game has been played. So it has been changed midway. The committee has been changed. No permission has been obtained.
Are you aware of the genesis of this case? You are not aware. The difficulty is this. There has been a consistent view which was taken that the rule of the game cannot be changed after the game is played. That's completely different. That is meaning thereby what? That at the time of an advertisement, you have said something, the candidates came, and thereafter a corrigendum or something, after everything is over, something is done where you said that these persons will not be shall not be entitled to participate.
Yes, that is
you are throwing them out of the zone. Then the rule was that it was said that once the game is played, you cannot change the rule. You'll have to proceed. It has got nothing to do with this rules, means the rules, statutory rules. Then Justice Chauhan of the Supreme Court, sitting with the three judges, that's the three-judge bench, doubted that principle, says that it can't be of a universal application. There are situations where the government or the recruiting authority may adopt some changes. So this cannot be the absolute rule.
No, they are
Then
correct.
referred the matter to a larger bench.
Yes.
And this is the judgment of a larger bench. Have you seen the composition?
Yes, yes.
How many judges?
5 judges.
5. So this is a larger bench decision that was taken or decided by this, upholding that particular old notion that you cannot change the rule. Here is a case where it is not that they changed the rule. They constituted a selection committee. But it appears that selection committee is not constituted strictly in accordance with the rules.
Yes, my submission is whether that permission has
Not a change of game
no.
or a rule.
It is my submission is whether that permission has been obtained.
It is not necessary. None of you are applying your mind. Now, we have to ascertain two things. The rule says, the proviso says, president can be a part of the selection committee. It is permissible. But only in a situation where the headmaster and the secretary are one person. One person who is also a headmaster, who is also a secretary. Then in that event, the president can come. He will be there. But the president may come. And Rule 5A says that if any member of the selection committee has a candidate who is related to him, he will not act as a member of the selection committee. Then what is to be done? If this is a catch 22 situation.
Yes, then
what to be done?
Who will permit?
No selection can ever be done except that this candidate who has a right to offer his candidature under the constitution, he shall be deprived. First, you will say you will not participate. You will not apply. Then and then, that means you are depriving or infringing a fundamental right of a person who has a fundamental right to offer his candidature in the public employment.
No, school has no objection if the person is getting appointed.
I'm saying. The situation is like this. Now, how to harmonize these two provisions? Any principle, any doctrine, any legal maxim is to be applied.
Only one judgment we have. Although I couldn't go through in details, but if the Lordship permit me, I can place. Of the three Supreme Court cases, page 57, also it is a income tax matter. There are 30 to 21 if your Lordship can
Whether thin it? No,
Case 50.
57.
Case 57.
There are 18 and 19 if your lordships, my lord. Only I can, otherwise I'll have to again search it out. This is the lacuna, it is the admitted positions. So what will happen? The secretary was not there, president was in.
So, the doctrine address against variant or variant.
Yes.
It's well known in other fields. But in this situation, what is to be done? That cannot be applied in that abstract form.
Because of the fact, my lord, and others,
Of bigger picture. Now I'm coming straight up. Can we apply this doctrine on bigger picture?
you have to search it out.
What was intended may not be manifest,
Yes.
but can be reasonably ascertained from the various clauses to have been included.
As a whole rule, if your lordships kindly give picture to the whole rule, well, intention is very clear. The related persons will not be accommodated or not be included in the selectors. That was not done. And other members, if there are one of the more than 50% members in the selectors, then it is permissible in law for approval of the panel. That is the judgment of Justice General.
The different context which provides.
No, Malad, this is the question was,
if there is a dissent.
No, question was, Malad, tell you.
Dissent and the majority will prevail. But here he talks about the constitution. Please consider. One is the decision by members of the committee, and another is the constitution of the committee. We are at the latter stage in the constitution of the committee.
Then the separate issue.
Is a quorum, but when you talk about the majority quorum or the presence of the quorum in a democratic meeting or in any other meeting,
50% is
the whatever, that is what is there. Here we say is the big fundamental one, whether this constitution was correct or not.
One next submission will be that is not the impugned order itself. The constitutions of the state.
This is what the impugned order is. That these are the persons. Not why the secretary is not there. Why the president is called. This is what the DI said. And the single bench said, when the rule says, how can you depart from the rule?
Now the DI said,
also forget about it. It's a pure question of law. Talk about it.
Then your lordships, I have to assist your lordships in other way. I have to bring out all judgments. Lordship, keep it. I'll try to.
ঠিক আছে।
What to do?
And I give it to your lordships, and if your lordships.
Dr. Patro, you come forward. Act as an amicus. Give him a copy of 2005 rules. Straight away come to rule 6. You got that? Rule 6. Selection committee. One E for selection of librarian. Have you got that?
Yes, yes.
We are not concerned. Come to B at the bottom. For selection of clerk. You got it? Or group B?
Page 417.
Have you got that?
Kindly just
B.
B, yes. Selection of group clerk
Clerk of
of group T.
That selection committee shall consist of headmaster. You got that?
Yes, yes.
Secretary. Then next, provided that if the headmaster and secretary are one and the same person, the president of the school authority shall be the member of the selection committee.
Yes.
That means headmaster would be there instead of secretary position, though he is also a secretary. President will roam in. And then the headmaster of the another school will come, Roman 3.
Yes.
And then Roman 4 is the nominee of the Panchayat Samiti.
My lord.
Noted.
My lord.
Now come to 5A at the bottom. Sub-rule 5A. Got that? Same. Go down. Thereafter 2, 3, 4, 5. Got that?
4, 5, next page.
5A.
Yes.
No person who is related by blood, marriage or adoption to a candidate to be interviewed by a selection committee shall act as a member of the selection committee.
My lord.
There is an embargo. Now very catch-22 situation which I said. The secretary says that one of the candidate is my relative before the constitution of the selection committee. I can't act as a member. I do not want to be a member. I showed my fairness in this regard. Please exonerate me. The school authority included president in his place. And then selection proceeded. The DI refused to approve the panel because the rule says the secretary has to be there. Since he was not there, so I cannot approve the panel. Back. Now the position is there is nothing which comes out. The president, if we go by a very strict literal interpretation, then president can only be brought as a member of the selection committee if the headmaster and secretary are one person. What would happen like this situation? Then either it has to be constituted with 3 persons, barring that person, one situation. or the president, when a president is included, maybe for one situation, the lawmakers cannot think of all the situations. So there may be some situations which may invite the president to be a part of the selection committee, like the one.
The ideal situation would be that the president will act in the place of the secretary.
Absolutely.
That would be the ideal situation.
This is what,
but sometimes other alternatives are followed.
Interpretation, if you say,
yes,
if you read proviso, it restricts to its applicability in case of a secretary and the headmaster being the one person. Which is not a situation here.
No. Here the situation is that the secretary
is different, headmaster is different.
Yes.
But secretary says I can't act. Because of the embargo of 5A. How to harmonize this problem? And
according to me, the best solution would be that the president, in view of the fact that secretary is
interpreted. Tell us what tool we should use.
to make a direct interpretation is a little difficult.
Absolutely.
But the fact remains that absence of secretary, president steps in.
Some tool of interpretation has to be applied.
My lord.
What tool?
My learned friend wants to bring in the mischief rule, but I don't think mischief rule is really covering this situation. This is actually an unforeseen situation. But if we assume that absence of secretary, the administrator, the president will step in, then even though the language of the proviso
has to be, that's my view.
Yes.
There is no other possible interpretation except that the president should be.
Yes.
How?
Here
to reach that destination is the big issue. Mischief rule is not.
No. In some situations, what happens, if I speak about the practical situations, then 3 people
That's why
do it.
there are possibilities.
Sometimes it also happens that I'm sitting for all of them, but when my candidate comes, the related candidate, I leave. But the ideal, that's why I started by using the term ideal. That should not be, because
is very clear.
Yes, the other members will be influenced by that. But the only suitable remedy, if we are to think of it, then the only thing is that the president.
Harmonizing this by using what tool of interpretation? Ponder upon it. That the Bari's contention is that the legal maxim at res magis variat quam pariat that can apply. That's one way of thinking.
Always in interpretation, we look for the workable solution.
That's what the at res magis variat quam pariat. That is what is the principle. That to make it workable, then to render it auction.
Right.
But in order to make it workable, there should be some other tool. If language suggests something else, then we'll have to interpret the language in that.
Every day we are learning for a very tough situations. We have
Language is clear. We cannot go by the fact that there is an ambiguity. That is also one hurdle.
He was really trying to have an easy solution for it. Referring Rule 12, interpretation clause. If there is any dispute with regard to the interpretation of this, then the government will be approached to interpret. Look at it. Then what is the role of the court?
No, let it be. I was writing a lordship and court can be called for.
That is when the authority has a difficulty in implementing a rule. It sometimes approaches the government under the rule that provision is given.
Was it Rule 12 of that rule? It's referring that. Referring the last rule. Interpretation.
This is common to all.
I know. The omnibus, omnipresent. Not omnibus, it's the omnipresent. Think about it.
Very good.
That's the only thing. More facts are required. When
anyone has subjective process after coming back any day?
the middle of the remark. Started listed on 18th March. Yes.
এটা অর্ডার করছে
Item number 21.
Item number
21.
এটা কল করেছে
20 চলছিল
কত রে
21.
21 হবে
My lord, we are appearing on behalf of the respondent
21.
number 8, 9, 10.
Lordship, I'm appearing for the respondent number 13, led by Mr. Vikas Ranjan Bhattacharya, and he's on his Mr. Vikas Ranjan Bhattacharya, and he's on his leg in court number 90. And I'm being instructed to pray for not this week, Your Lordship.
My lord, Mr. Ahmed is appearing on successive occasion. Time has been sought for. On previous occasion, my lord, when
last occasion I said I am not going to give you a time, then out of the scene.
And new person has been inducted.
Face the wrath of the court.
Don't have the brief also.
And we are dismissing this matter and don't carry the brief.
Can you make thought possible so I can?
Where is Gulshan Vara Parveen?
She is in court number 35, Mr.
We can't do it. We are dismissing it. When she is ready, solution, what is the problem? My old adoption of the procedure was correct.
Yes. That was correct, my lord.
I will not restore, argue on the merit on that day. I will
My lord.
The moment I restored, now it is the game of dismiss.
বিকাশ দার নাম নেই বিকাশ ভাই আমি অথরিটি না
22.
Appellation. this last many occasions, the petition was sought on the ground of unavailability of the senior advocate representing the last occasion. It was pointed out to Mr. Ahmad, the learned advocate, here and sought for an explanation that the matter that he being one of the counsel has to argue the matter.
Nice.
It is distribution, not for the applicant. But here the dispute, my lord, is with respect to the appointment of the headmaster. But what happens, my lord, here that the individual
always appear when there is a dispute either of an assistant teacher, teacher in charge, or the headmaster.
So, my lord, but
Take your seat. Let us go. Yes, the panel expired. They say that everything is exhausted. What remains?
I tell you, my lord has
So
seen.
before my learned friend starts, may I just remind your lordships, I had taken the ground that there was a suppression of the material facts. And to that effect, I was directed to file an affidavit, which I have filed on a previous date. The petitioner was directed by the learned single judge that a personal hearing will be given to you. That hearing was conducted. On the, no, but on the returnable date. No, but
I tell you, lordship, I'm coming back to that.
no,
I'm coming
but
to
you attended the hearing.
Yes,
You
yes, of course.
received the reasoned order and you come up in appeal suppressing the fact.
No, because
I am not.
Doesn't.
No, why I'm telling your lordships on the, if your lordship sees the previous order, there was a direction upon the commission to give the petitioner a personal hearing and pass a reasoned order.
Yes.
Yes. In compliance with that order, the petitioner attended the hearing, reasoned order was passed and communicated and given to the petitioner. On the returnable date before the learned single judge, when the matter was taken up, we were unable to produce before the court, though the hearing was over and we had intimated the court. Court said it is not necessary because I am not entertaining the writ petition and dismissed it. But the fact that the reasoned order was passed and the reasoned order is in the hands of the petitioner, that information at least should have been part of the stay petition. I had taken this ground on the last occasion. The reasoned order gives a new cause of action, explains categorically why you cannot be accommodated. Then how come you come up for adjudication against the...
My
Kindly see the affidavit which I have filed.
But may I just, my lord?
My learned friend has also
May I, my
used
lord,
an
apprise your
exception
lordship?
to it.
Yes, yes. May I apprise your lordship?
I did not really notice when I was reading the
Yes.
last line is reflective of this.
Yes.
Says that the reasoned order filed today on behalf of the school service kept on record.
Lordship.
That means the reasoned order was there.
There. My lord, lordship kindly appreciates the reason why, my lord, I came up before this honorable court in appeal. That after the reasoned order was passed, the honorable single judge, my lord, rejected. It is not the case that this reasoned order was taken into consideration and rejected, which, my lord, resulted in a situation.
That it was taken, you are free to challenge that reasoned order if you.
Well, that is exactly I was praying before your lordship, because the honorable single bench's order after this, I cannot even challenge the reasoned order. That
No, I
is
am
exactly
not.
what I'm praying before your lordship. That is what I'm praying before my lord.
Uh, it is since the appellant is relegated, since the appellant has been granted liberty to challenge the recent order before the appropriate forum, comma, the the exception taken to the report shall not be deemed to have been dealt with by us in the institute.
And my lord, may I also prefer a liberty so that my lord, so that my lord, they do not take the point of limitation. Because if they take this point of limitation now,
Yeah. Yeah.
I did not take the point that this case has not been made out in the appeal, which my learned friend is now saying that this is what I wanted.
grateful.
23.
My lord, 23 is for the appellant, my lord. But the apparent insurer has come up against an award passed by the Commissioner Employees Compensation under Section 30 of the said Act. The delay has been condoned earlier. The principal.
Yes, looking under Order 41.
Yes,
there
my lord,
is an
on the
order.
last day when the matter appeared before your lordship, your lordship directed my lord's officer to let it appear as under Order 41. But not again today, if your lordship kindly have a look at the last order.
এখানে order আছে. The matter is wrongly listed under the heading application, though it should be listed under the heading Order 40. First legislation.
Not under Employees Compensation Act, your lordship kindly have.
It is a employees compensation.
Yes, sir.
Oh,
Employees Compensation Act.
yes, it is there. Then admission under Order 41 Rule 11 give instead of আরে দেখে নিয়েছি এটা employees compensation আমাদেরই কাছে আছে. This is the matter tomorrow as Order 41 Rule 11.
Gotcha.
Or লিখে দাও Order 41 Rule 11 না করে for admission করে দাও.
For admission.
Ready করো.
Grateful.
Take it.
24.
24, I am for the appellant, my lord. May I prefer short pass over, my lord?
I think short put reading court number 32. Mr. He is senior, court number 32. Short pass over কি হবে?
We are very senior. You are talking about.
I think not today.
Out of time.
Yes, my lord. Because I preferred a review application, my lord. For that reason, I have explained in the Section 5 application also. My lord, delay is for
the review application what?
a review application against this order, my lord. This impugned order.
511 days.
Yes, my lord. My lord, kindly sees. But the application of review was filed on 23rd December 2022. My lord, the order is on 30th November 2022. I filed the review on 23rd December 2022. And my lord, my review got dismissed on, my lord, 14th March 2024. From paragraph 2 to paragraph 5, my lord, I have stated the grounds of delay, my lord.
Yes, what do you say?
Delay with the Section 5 application, I don't know, not to touch. But he filed his application and already received the money. CPF to GPF. He received the money from CPF. Now I filed this application against her. Read application dismissed, then a review application dismissed, then again we file visit application.
What to do?
I think this maintainable also, I think. CPF, on the basis of the CPF, the application was for option.
Indeed, but Section 5 has to be.
This is up to my lord's. Section 5, I don't know. I wanted 11 days.
That within 30 days, I have preferred the review application.
Ashish, I তুই আসতে পারবি তুই তোকে তো ঘন্টা মিছিল দেখ
Wanted to switch over after the retirement.
Only Millard, Millard, my option was exercised on 24th December 1991 CPF to GP.
When after retirement?
No, my retirement was Millard 31st August 2018.
So,
and 2018, and it was 1991. Option was they are not accepting my proposition. Problem is, Millard, when I preferred the second read before the Honorable Single Judge, Millard, there was an omission. Although Millard, the matter was on record. Honorable Justice Boshak's order, Millard, which is staring at the face, Millard, had it been considered by the Honorable Single Judge, possibly I would not have come before your Lordship. Kindly seize the order dated.
then why you could not actually review?
I reviewed, and the review failed.
So,
And Millard, my review was dismissed by the Honorable Single Judge by saying it's an appeal in disguise. You take all these points before the appeal court. Kindly see Justice Boshak's order.
Page 212.
Page 212. Page 212. 212. 212.
Yes.
Subject to correction, Millard, this issue is no more res integra. Kindly seize. May I read for my lords?
you are not getting a pensionary benefit.
Only CPF. Now the government was under obligation to inform me as to what should be the actual amount, quantified amount. I had to return and I had to submit. Now, my lord, the Honorable Single Judge.
It was not there. You have not stated that when you applied for.
No, my lord, that was not the issue. That was no, that was. Miller, first Miller, this surface Miller in 2021. Even after Miller, the matter when
2022 contributory providing fund you received.
No, I received Miller on the day 2020. 2020. No, Miller 2021 it received Miller, but this 20 Miller 20 Miller 20. No, nothing was surfaced. It after this order was passed, Miller, there is a report, and Miller in the single bench, the Honorable Single Judge directed them to file an affidavit stating that whether the particular signature that Miller that is imprinted on the Miller the option form that was excised by me in the year 1991, it should be verified and authenticated. No affidavit was filed by the government, and Justice Boshak's order 27 to 11 2022 was not placed or considered before the Honorable Single Judge.
That was simple. That there was a bifurcation.
Record has to be reconstructed. Record has to be reconstructed. All the pleas were not found to be tenable. Admittedly, the petitioner retired from service. She is entitled to retire on pensionary benefit. Definite finding. The grounds for rejecting her claim as stated in the impugned order dated such and such cannot be accepted. Such grounds are not insurmountable. Authorities.
Petition where you have challenged. There is that petition in which this order of Justice Boshak
Justice Boschak's order stands in my favor.
No, it does not find. Readings there of that petition.
Oh, that petition I will submit.
Definitely, because it is.
Yes. My lord's desire is a command. I will. My lord.
Pensionary benefit, in a very loose sense, sometimes it is used.
I understand, my lord. I have to win my lord's conscience, my lord, after my lord proceeding.
Show us that petition.
That is not with.
You have raised this point.
Right.
Propose this
I understand, my lord. I understand, my lord. Fair enough.
Lordship, here is two things, Lordship. Kindly page 253. That is forced document. We produce the option. First option is paid to 1985. Thereafter, forced document file 1991. Lordship, 253. That is forced document. How this is that is Siti Bhattacharya. Siti Bhattacharya at that time hit mistakes. Siti Bhattacharya hit mistakes.
If it was called for from you.
No.
Find affidavit.
Page 186, my lord. My lord, with deepest respect to his understanding of the fact, my lord. Page 38, 186. I am to, this is the address to the headmistress, pro forma 9A. I am to inform you that I am due to retire, have been retired from service with effect from 31st August 2018, and as headmistress of such and such high schools, I have resigned finally from service such and such with effect from 16/1/2009 as assistant teacher, and my resignation has been accepted with effect from. Please take necessary steps for final payment of balance standing at my credit in my GPF account may be made at the earliest convenience by depositing government share, if any, in the government treasury. I have been appointed. So 18, my lord, this is dated, my lord, 17th December 2018. This was given to the government. Yes, that point. No. Now, my lord, when that is why, right?
Say you exercised that option in 1991.
Right.
As an assistant teacher.
Right.
They say they are now saying that is a postdoc. You say that this.
That is, yes.
Justice Bosak has taken note of it. And once the direction was passed for a retirement pensionary benefit, means implied. Justice Bosak has accepted that you are coming under GPR, otherwise pensionary benefit. That's your perception. My perception has not arrived as yet or match with your perception. This will match only after looking at government.
I stop here, Miller. I stop. Give me 14 days time. 10 days.
That is forced document. Lordship, he produced. Thereafter, he received the money 4,90,000 on the basis of the CPF. Now he claim writ application dismissed, review application on that ground, Lordship.
If Justice Bosak's order is staring at your page, then how a coordinate page pass a just contradictory or just opposite, diametrically opposite order? That report is contingent. The Justice Bosak's order has not been taken care of. Whether it was placed, not.
And Lordship, the school authorities must be present and he's answering question. School authorities not come, serve the question. What is it?
না আপনার সন্দেহ দূর করার জন্য আবার দিয়ে দেবো। আপনি যখন ডিআই ছিলেন
না, আমি তখন ডিআই ছিলাম না, কিন্তু আমি ডিআই আসার পর দেখলাম তো সমস্ত কোর্স ডকুমেন্ট। At that time, he is his headmistress. Course document 1985, he first option. Thereafter, he joined the headmistress and course document produced that in 1991. That is page 293. That is main option. 1985.
নিয়ে আসি আগে দেখি।
My Justice Amita Sinha, that's why Lordship dismiss the application. Then review, then dismiss.
এগুলো আপনি পেয়েছেন, নথিতে পেয়েছেন?
এই তো নথিতে আছে, তো এই তো দেখছি, তো দিয়েছি, তো তোমাদেরও দিয়েছি কপি।
বলতে দেন।
Enable the council for the applicant to bring the relevant documents. Let this matter be listed after.
25.
Should I have fear for
There's an application for condonation of delay. It's quite 1538 days.
Like to the affidavit because of the enormous delay
4 years and some months. 4 years, some months.
That's why I say because of the enormous they are inviting, so that's your right to file. What
Yes, me too.
after hearing the parties. Respondents are directed to file affidavit opposition to the application for convocation of the within
কতদিনের মধ্যে?
3 weeks.
3 weeks everybody is asking.
Don't believe him.
Some
Lucky that you have found him with you. Very difficult to find him.
well, leave to appeal is also pending.
Reply.
Week.
Application.
The Lordship is directing for affidavits against only the section 5.
Yes.
Both, sorry,
There is the leave.
leave to appeal and by both.
There is the leave. There are 2 hurdles. Right, 2. Getting into the matter.
No, you take personal responsibility.
At this age.
Considering the junior attached to you.
কেন জজের ডিসপ্লেজারে কেন দিছিস এত?
Never found out the first call.
No, I have rigs.
One or two.
I will thrash him. I will thrash him and make him.
Except one or two matters sometimes. In several months, suddenly one day. That is not job.
Well, I will see to it that he comes.
But this
Day, one of the lucky day that the first.
Continuous.
I will see to it.
Can't do anything. So Tapan Kumar Mukherjee would not do how much object.
তপন রয়েছে? নেই।
Yes.
এই আমাদের application.
দুটোতেই দিবি, ওটাতেও পার্টি ছিল না।
26.
But I'm for the evidence. Your Lordship may remember particularly handicapped matter. Certificate, regarding certificate. Today I prayed for fixing a date. An application was made by my client for fixing a particular date.
What?
Made an application for
Fine, allowed or not?
Well, the paperwork have already been prepared. Application was made for fixing a date of hearing.
But you don't find any order of section 5.
I'm filing this paperwork, my lord. Yeah. Suppose, Mr.
No, there's no order sheet. Oh, I'm sorry.
Yes.
Why?
কাগজ দেবেন আমার একটা দেবেন
Yes. This is an application. Which application?
Application.
CAN2 of 2025.
Within 2 weeks,
Update.
I'm deeply obliged.
But it makes sense.
I'm grateful.
28. My lord, I am for the petitioner respondent.
I am appearing for the respondent Poschimbango Somogro Shiksha Mission.
While you are a
I am not the appellant, but respondent.
You are also for the respondent.
Yes.
Writ petitioner.
And I succeeded in the writ petition. After 13, after
Ado.
2007 থেকে কত?
2007, 24, 17 বছর।
After 17 years, I succeeded before this Honorable High Court to get the job of a para teacher. And how long I will survive? After 17 years of legal battle, I have succeeded. Since the appellant is not here,
See, there is no stay order.
no, we cannot file, we have not filed an application for contempt, and as because the matter is before his lordship. As I advised my client not to, and they say, local authority said that unless the appeal is completed, we cannot pass any orders. We will not pass any orders. Then I could not file any application for contempt because the appeal has been preferred and stay has been filed. We have been waiting for this, and moreover,
Appearance on behalf of the appellant. Let this matter go out of.
Make it not today, my lord. Let me inform Mr. Siddiqui. Otherwise, my lord, I shall also suffer. My lord, although, my lord, I am appearing as
he is not an
respondent,
appellant.
but
Why is so interested? Why is so interested?
For a contempt, whatever.
Let him
Well,
let,
kindly make it not today. Kindly make it not today.
let,
Or kindly, my lord, give a short passover.
let it, let
Otherwise,
it,
because of state, my lord, I shall suffer.
Yes, call the next.
29. Suffer, you go out. এই পিনাকি ঠিক আছে পেনশন পাবে পেনশন পাবে পেনশন পাবে খুব অ্যাপয়েন্টমেন্ট হবে
এটারই
হিসেবে রুলসটা রাখবে হিসেবে রুলস করবে হুম তো ইয়েটা মাস্টার দো ওটা তো আপনি প্রিন্ট সব কপি
না না বলছি ফিরে রিডিং হয়ে থাকে 8:30 4:30টার সময় ফিরে ঘুমিয়েছি কাল রাতে কালকে আবার রাত্রেবেলা রিডিং করতে জানি এখান থেকে ব্যান্ডেজটা বেঁধে দিতে ভালোভাবে বাঁধে বাড়ি নিয়ে এসেছি পুরো খাটপাট বেঁধে গেছে বলছি আমি
PCRB rules জানিস?
PCRB কি দরকার আছে? Only your lordship heard the matter, directed Mr. Mukherjee to take instruction. What has happened, my lord?
There was no appearance from the other side.
Oh, on first day, there was no appearance. Your lordship directed Mr. Mukherjee to serve a copy. I served. Thereafter, matter was again taken up for consideration by the court. Court directed, put some question to Mr. Mukherjee and directed to take instruction in this matter. Question is, my lord, for the post of the assistant teacher in language group, the post was mentioned as an additional post. And following regular recruitment rules, I have been appointed. The managing committee prepared, hold the interview, prepared a panel, panel was submitted, panel was approved. I joined there for a period of 2 years, thereafter 1 year extension, thereafter, my lord, after 4 years, it was detected, no, it will be the lien post. It will be the lien post and you should be removed from the post. Then while I came before this court passed an order, setting aside the initial interim order, thereafter final order, set aside the decisions, thereafter matter remit back to the Commissioner of School Education. Commissioner of School Education again repeated the same.
By this time, how many years passed?
28 years, May 31st, I superannuated, 28 years service I have rendered. Now, my lord, I
On the basis of the interim order.
filed an applications for releasing of the pensionary benefit. The court considered the matter and took up for final disposal. And court said no, there will be no recovery, but you should not be allowed to get the retirement. He said that. No. The lordship had checked up the panel, page 47. Page 47. Appointment of
Long and late.
the panel. Page 47, lordship body.
The word used is long and late. Under language and literature.
Yes. The panel for the following candidate for the appointment of the assistant teacher, language group literature, in additional sanction. In additional sanction post, by this office member number such and such, with their letter under reference hereby approved. Motion Gayu is before your lordships. He is the first and current candidate. Now, where are the appointment letter next? The appointment in the language and literature. I joined. Now, my lord, every post your lordship knows that the for temporary for a period of 2 years, thereafter the
Advertisement inviting this.
This advertisement was, but it is not on the, it is on the, my name was sponsored by the.
There is a difference.
No, page 49, 2 years.
No, set up okay. Advertisement which way? It is not name was sponsored by the employment exchange.
Advertisement I have not annexed. My name was sponsored by the Employment Exchange, and that I have said so in categorically mentioned para 6 of the rate petition.
স্কুলের কাছে থাকবে তো স্কুলের কাছে থাকবে
স্কুল কেন ডিআই অফিসেও থাকবে
না না আমার কাছে দিন
না থাকবে
at that point of the school was advertising.
Yes. No, that advertisement copy is not with me at present, my lord. But my name was sponsored by the Employment Exchange. School authority sought for candidates from the Employment Exchange having requisite qualification post of the language and literature group. And I was interviewed, regular selection process, appointment letter was given. I've been working all along. And 31st May, my lord, I retired from my service. They can show the advertisement. The district inspector school.
No, at that point of time, managing committee was the authority to advertise the post.
You approved the panel after receiving
But
all documents.
provident fund has to be deducted first. Before confirming the kind of the finding of the learned judge, no amount has ever been deducted from petitioner's salary towards provident fund. Provident fund deduction has to be made. Before provident fund deduction, that means confirm. Never confirmed and approved. And he continued with the interim order of this honorable court. Now he wants a pension. Pension, there must be a post. There must be a provident fund deductions.
That gentleman absent, he was appointed.
He has been appointed as headmaster of the school. Headmaster.
In the prior permissions and in the preparation of the panel, it was categorically mentioned the additional post. Categorically mentioned additional post. After some times, it was detected 3-4 years. It was no, the post was the lead vacant.
What is the difference on the additional post?
The leave vacancy, my lord, for the temporary period, initial advertisement, it is being advertised for a period of 6 months or my lord 1 year, and lien post is maximum 2 years. And there will be a specification that is the post of the lien in the advertisement and in the prior permissions. And one of the all candidates are not applying for appointment of the lien vacancy because it's the temporary. Now I worked there from very inception of the schools. And I made an advertisement. I participated in the selection process through the Employment Exchange sponsorship list. And my lord, the panel was approved. I joined there, and I have been working. And your lordship. Yes.
On the page 49 for a
Rightly, wrongly, they have.
Foundation Gawat BA, assistant teacher under language and literature group, in additional sanction post for 22nd March, date from which approved 22nd March 1992.
Something more post which was given.
No, if the post is not permanent or there is no available vacancy, then additional post can be sanctioned by the government. But he joined in the lead vacancy of Mr.
Where do I get it that the word leave vacancy is used? Anywhere in the document or anything where you have issued any letter.
But can you see page 49? Date from which approved 22nd March 1990 to 22nd March 1992, temporary for 2 years.
That is the different things.
No, in the said memo in the post, it has mentioned in additional post.
This is additional post, sanctioned. Additional post was sanctioned. Then you have kept him for 2 years. Definitely after evaluating, then you will definitely make a permanent.
15th April.
Then what about 50? What about 50?
Just a minute. The undersigned has to state that the appointment of Mohsin Gaud, B. Assistant Teacher under Detail Group in normal vacancies hereby approved on a salary admissible under rules for 1 year from 1992 to 2000 on usual terms and conditions. 1 year.
In a normal vacancy.
Normal vacancy for 1 year. Not for more than 1 year. Now post has to be sanctioned fast. Approval has to be granted. Unless now after retirement, no approval can be granted. Because for getting the pension, he must have a contribution to the provident fund and contribution to the GPA, contribution to the group insurance. Nothing is there. No approval is there. Who will pay the pension? Whatever the salary he has got, the trial judge has said that no recovery should be. We are not expecting any recovery.
Last time it was mentioned in page 51, that is the leave vacancy. You should not permit him. Then, my lord, a challenge was thrown. This was taken up for consideration by the court. Ultimately, interim order was initially granted, and finally it was set aside. Matter remit back to the Commissioner of School Education. Your lordships, kindly have a look to this order passed by this court. The interim order is page 57, and thereafter, my lord, page 60 is the final order.
একটা particular school এর জন্য। No, ওটা অফিস নেই, ওটা অফিস নেই।
Now, Commissioner of School Education passed an order, starts from page 64, and said was challenged, and the interim order was granted till, and I received the salary till my date of superannuation.
But if you got the on the basis of act on the basis of the interim order of this court, when
Yes. And categorical observation was there, page 61 top, if you lordships kindly take trouble. In fact, when the order of the DI of the school approving the payment, dated 20th March 1990 states that the appointing is in an additional post sanctioned by the office of the order number such and such. When an additional post has been sanctioned, the question of the vacancy may not arise. And this is also following recruitment rule.
না 2007
If it is a leave vacancy also following the recruitment rule. It is not the backdoor entry.
2007
Our one division bench, their old order is the workable order, presided over by Justice Banerjee. He has held the division bench. If the initial order is if the following the recruitment rule process, if anybody is appointed, he should be approved in a leave vacancy on permanent basis. That judgment I placed before the single judge. It was considered, but
Localized to eight.
Yes, Mr. Mukherjee.
But can't see.
What is this order was set aside subsequently that you can't treat it him under the leave vacancy.
But kindly see.
Sorry.
No, kindly order of Justice SBC na.
SBC passed an interim order.
Yes, but page 57, the payment of salary to the petitioner.
That goes against you, sir.
No, but kindly see, the payment of salary to the petitioner may be made subject to the condition that the petitioner shall give an undertaking in writing before the day of school, secondary education, Uttara school.
Was that the court was satisfied that he has made out a good prima facie.
Petitioner shall record entire salary be drawn by him. He has given an undertaking. Now he is entitled to refund now.
It's come to Justice Ansari's judgment. That was an interim order.
Yes.
Final order of Justice Ansari.
Yes.
Read.
60. 60. Yes. It is known to the basis from the deputy director.
This is from concept of leave vacancy. From where it arrives.
Yes.
When it's sent to the
But may I place the entire order despite directions court ordered? Opposition
You have to read it.
Yes. But kindly see the last.
Justice Ansari has said.
Page 61. In the result, the writ petition is allowed in part setting aside the impugn order dated 9th August 1994, contained in memo dated XLF, liberty granted to the Director of School Education if considered appropriate by him to initiate fresh such proceedings against the petitioner as may be open to him in compliance with the principle of natural justice. Until such proceedings are taken, the service of the petitioner cannot be interfered and shall accordingly continue if so directed. Petition accordingly disposed of.
So,
Then
this is the 1994 letter at page 51, which was caused and set aside.
yes.
Then you again you passed an order.
Yes.
Again it is set aside subsequently by Justice Sinha. No, this was by Justice Korgupta, interim order was passed.
Yes.
And then ultimately by this.
Yes.
So,
but kindly see, but if somebody does not contribute in a provident fund to get the only question of pension, government is asking for refund the amount because there is no appeal by the government. At the present moment, only he will get the pension or not. No more other questions is arise. If there is no approval of appointment, then today we shall have to give an approval from 1992. Post has to be sanctioned.
the post is already sanctioned.
No, post is for only for 2 years.
As per the PO dated such and such, the additional post was sanctioned. And then the appointment was made only for a petition period of 2 years.
In a leave vacancy. In a leave vacancy.
It's a leave vacancy. First time you talk about leave vacancy in the document of 1994 at page 51.
Yes.
Which was passed and set aside by the single bench. By Justice Ansari.
Yes. 8 July 1984. Justice Ansari order has been
set aside this.
9th August 1994. But can you see the order at page 64, 9th August 1994. But this is 8 July 1994. Sorry, in bottom 9th August. This order has been set aside by Justice Ansari. This order has been set aside by Justice Ansari.
That's what it means. When you can't rely upon the statement made therein. Can
No.
you?
Oh, no, if set aside by this honorable court, accepting this. No, I'm not saying that. If this order is set aside, has there any order that he should be approved in a post? Is there any one sentence there to grant him approval?
Then what for the existence of a high court is there?
To justice to the party.
And to to nip in the bud the injustice by the authorities,
by the administration.
by the authorities. It is really in pursuit of rendering justice against injustice.
Yes. Government also asked for justice from the court.
Now,
We shall have to pay taxpayer money. Yes.
none of the letters issued by a government, now I'm using the word government, borrowing from your expression, indicate that your appointment is against a vacancy. You all along took a stand that you are appointed against an additional vacancy or additional post. First time you use the leave vacancy in 1994 document, that letter, which was caused and set aside, means the court did not accept that it is a leave vacancy. Justice Ansari flagged an issue saying that how can it be? Once you have used the word additional post, how can there be a leave vacancy? Yet directed the commissioner to take into account. The commissioner thought that he is above the court.
No, certainly.
Above.
No. Certainly, why?
He's above the court.
Executive, always the executive. If
Findings are useless. The courts do not really use the words in a very clever sense, nor in a very meaningful manner. Of no use. Let me use my the authority. Let me exercise my right. Pass the
according to their understanding, according to the rules prevailing there.
because their understanding is better than the court's understanding.
I do not know. I don't have
That
it.
is what is appearing better. Obviously. And borrowing something which is discarded by the court on the other of it. Every time there is one repetition leave vacancy, which has not been accepted by the court, saying that I do not accept it is a leave vacancy. It is against the additional post.
Assuming for a moment additional post, there must be a selection for advertisement. There must be a selection procedure.
This is what has been done.
No, but there is a
Sir, if your rule provides, please, Mr. But I did not expect this argument from you at least. Are your authorities approved the panel with the closed eyes? Are they not supposed to go into whether the recruitment process has been followed or not? And then approval. You are saying whether it was the rule was followed or not, then your authority approved.
Yes, approval is there.
Means there was all the rule which was followed, and your authority was satisfied that the recruitment rules have been followed.
But only for 2 years. No, but only for 2 years.
Is there any different rule that for 2 years this is the recruitment rule? For the other permanent, this is the recruitment.
Yes,
rule.
there is.
There is. Show us that there are.
No. If Route 28 is there, Route 28. 1969 rule start. Appointment are approved. But this order, page 69, subject to correction by my learned friend, has not been set aside by any court.
This is the subject matter of challenge here.
No. How it could be? This is a order of 1991. And a writ petition was filed in
1991 order was not challenged. 1994, 1991 is in their favor.
No. 1991, he was given approval for 2 years. Am I wrong? If I wrong, kindly admonish me.
I make no comment.
Now, if I have committed wrong, kindly admonish me so that I can correct myself.
No, not necessary. Not of any use.
Now, Malab, he has to be giving pension. That is the only question to be decided by a lot of
1991. So
yes.
the appointment was against the additional post sanctioned V-Day GO number such and such of 1988.
Yes. 15th April 1988.
I read it here and still memorize everything. And in the last column, it says that your appointment is for a period of 2 years.
3 years.
Temporarily for 2 years.
2 years.
Next document, next page. It talks about an extension for another year.
Yes, sir.
And the next page, it says that how can it be? It was a leave vacancy. How can you continue with this? And he has the gentleman who took leave, in his place he was appointed, is now appointed as a headmaster.
But this order,
This appointment cannot be regularized. This is illegal. You said in 1994 letter.
has been set aside by the Supreme Court.
This was challenged by them. Then how can you say now?
No, but if,
Set aside this
brother, but I'm accepting this.
that if it is an additional post, sorry, that's why I raised an issue. If it is an additional post, how can you treat it as a leave vacancy? Again, I am saying,
No, but
have you abolished the additional post? Like an ex-cadre post when it is created for temporary purposes to meet the accumulation of the work. So,
and I think government should be given a little time to file an affidavit disclosing this, all this 88 circular and other things. No, but because this is until unless part of the records, I cannot argue.
absolutely, it continue. It becomes a regular vacancy because that gentleman with the own that was appointed as a headmaster. He is not working as an assistant teacher.
Malab for additional post, there is no such different recruitment policy. For additional post, regular. Yes. And my lord, if it is
one of the sanctioned for
our division bench has held, even it will leave vacancy. If that gentleman subsequently resigned from the post, it is entitled to them.
Well, kindly give just 10 days time to file an affidavit. Just disclosing all. No, because in the trust.
Thank you, sir.
No, lower court.
No, whatever, principal let down, your lordship can be.
Now, only question whether he should be paid pension or not. Nothing more. No other question. That's all. Give me 10 days time so that I can file an affidavit on the basis of the 88 documents and
problems that really always enhances or gives impetus to the member of the bar to ask for an exception.
No, I'm not sure. Because until unless it is a part of the record. No, until it is a part of the record, it will be proper for to argue the matter. But it would not be until unless it is a part of the records, it would not be proper for me to say something. Because whatever disclosed in the stay applications, I'm on the way arguing this on that. Nothing more.
You have filed your affidavit in the transport.
Several, it was heard at length several times. Well, they produced the records, they did not file affidavit. They produced the records. And it was hotly contested matter. Your lordship kindly argued at length. Your lordship kindly see the order. The records.
For the first time, you should be permitted to make out a case.
No, I'm not.
Sorry.
When a person to under direction, I've got instructions. Bunch of paper.
And total service rendered.
Kindly excuse me,
28
April. Just give me 1 second. 15th April.
They have taken service.
No.
Deny the pension.
But 15th April 1988.
Accepted the
No,
order.
but just really 1 minute. 15th April 1988 is troubling people. In view of the above fact, the school is multi-questioner one as resolved by the managing committee. Permission for appointment of one duly qualified assistant teacher under language interview hereby accorded on a temporary basis for 2 years.
All appointments are 2 years.
No. Kali see this document.
আছে তো রিটি তো আছে
No, 88 ছাত্র এই আরেকটা দেখতে যাচ্ছে
আমাকে একটা দাও
কিন্তু আমার কাছে এটা থাকবে
ঠিক আছে, দাও না।
he is harping on 88 circular. Can you see the 88 circular?
আমি সার্কুলার হার্পিং করি, রেগুলার রিক্রুটমেন্ট ফলো। সার্কুলার কেন হার্পিং?
This post is from 88 for only for 2 years. On that post, he was appointed. This is a sanctioning memo.
দাও, দাও।
No. This is you are bigger order.
হ্যাঁ, এটা দেখাও তো। আছে। আছে।
2 years or until the headmaster becomes qualified, whichever is earlier. This is his original sanctioning memo. Is a permanent post. If it is permanent post, I have no reply to your lordship.
Not an exploitation of human resources.
He could have asked the court because he, on the basis of the interim order, he continued in the post till retirement.
You have accepted.
And since interim order merges in the final order. If an interim order passed in a suit, that terminates in the final degree. That is the basic concept, everybody knows. In 94.
Just give him a copy.
Yes.
Of tomorrow. Just go through it. These are the.
দাও, কপি দাও, কি দাও?
Give him a copy.
না, আমাকে দাও।
আমার থাকবে তো, তোমাকে
জেরক্স করে দাও, কি আমি জেরক্স করে ফেরত দিয়ে দিচ্ছি।
My lord, to mention that 28, my lord, I was not able to appear. Not I am the applicant, my lord. I was engaged, my lord. Another court, my lord. Go out of the list, my lord. Kindly make it not today, my lord.
এটা তো একটা কপি চেক। এতে আছে